for matters data protection. Our meetings are recorded and uploaded on YouTube and shared with others so that they can also learn from these meetings, especially those who are not able to join us during these sessions or at this time because of other things. My name is Daniel Oduor, and we'll be going through conveyancing today. But of course, as our norm, we always begin with a word of prayer. So I'm going to pray for us just before we begin. So let's believe and pray. Our Father, what in heaven, Lord, we thank you so much for this evening. We thank you so much for this day. We thank you so much for convening us here. We thank you so much for these sessions. We thank you for everyone who is here, Lord. As we discuss conveyancing today, may you help us and guide us. May you lead us all through the paper that we're going to discuss today. May you help us to think and to understand and to come up with the right answers. King of Kings, may you take over this session. May you help us to concentrate and to learn and to remember. And it is in your mighty name that we pray and believe. Amen. Amen, guys. Pius, just before we begin, I'd really like to hear from you guys how I think someone, Hilary, your mic is on. Maybe if you can mute. Hilary Oduor. Okay, Pius, how is it so far? How is it going? When are your exams? How are your preparations like? How is everything, man?
From my hand, everything is flowing on well. The exams are supposed to begin on 16th, tentatively. So we are waiting for the timetable. I don't know how many weeks are they normally sharing the timetable with students, but maybe from experience, you will tell us during a year what amount of notice were you given before you started the exams. In terms of classes, I think this is we are remaining with like 3 classes for every unit. And so far, so good. It's been tiring, but of course, we really benefit a lot from the sessions that you conduct every Saturday. And we feel forever indebted. Thank you.
All right, Pius. Thank you so much for that feedback. So far, so good. When you say 16th, you mean 16th next month?
Yes, 16th November.
16th November.
24. Yes.
Okay. That's good. Guys, so we are nearing the tail end of this journey. And I think for me, the advice I can give you right now is that just put in the effort for now. Just do the best that you can for now. A time is coming when you'll be thinking of these days as the past. So when you have this moment, just try. I know that all of you guys are trying. I know that all of you guys are pushing, but I'd like you guys to know that there's light at the end of the tunnel. This too shall end. I'm not talking about this because I'm not saying or talking like this because it's life and death. No, it's not. But just put in the amount of energy that you're able to put in now. And I want to believe that it will bear fruits. And I want to believe that you will pass your exam. So however tough it is, if it is, that is, however confusing it is, just do your best. Again, one thing that I always say in this session, and I think that we always share here, is that you guys are brilliant people, man. For you guys to be able to reach where we are here today, it means that you guys have put in the work. It means that you guys have pushed. It means that you guys are not stupid people. So I just like you guys to believe that and to know that if you just decide to sit down and read, these things are doable. These exams are exams that people pass. I mean, we've been doing exams for a while, since class 1, since nursery. I don't want to say it's the same type of exams, but it's just exams. If you get ready, if you prepare yourself, you can do it. Now, the reason why sometimes we talk about this or belabor on it is because there are people who want you to believe that CLE is very tough. it's one of a kind. You won't be able to pass it, or people have failed this and that. Everyone has their own story, man. There are people who have passed, there are people who have failed. Which story are you going to write? Your story is not like mine. Your story is not like for anyone who has passed or anyone who has failed. You're writing your own story. So it's not about people who have passed. It's not about those who have failed. I want to believe and know that you can also pass, and you'll also be able to pass. So just put in the work, have an open mind, read whatever you can, try your best to ensure that you're using your time in the best way, and you're going to cruise this. You're going to cruise through this seamlessly. Just put in the work. And again, just to reiterate, we are brilliant people. You know, we have future senior counsels here. We have future judges here. We have the future chief justice amongst us here today. You guys are the ones who are going to do it. We are the ones who are going to do it. We are the ones who one day are going to be at the helm. We are the ones who will be leading at one point, and we can do it. And so for us to be at that, you know, to be leaders, we have to go through stuff like this. We have to show that we can actually do it. And this is one of the ways through which you show that you can do it. So be fired up, be ready, just do your best, know that you can do it and it's not impossible, and just keep going and keep moving. Guys, it is possible. Do not let anyone convince you that it is not. Do not let anyone tell you that you need to move mountains for you to be able to pass CLE. You can do it. Just relax, do not be anxious, do whatever you can, and those marks will come. All right, so today we are going to discuss the conveyancing paper. We are discussing the March 2023 conveyancing paper. And so again, I'd just like to request any of you, Chelsea, if you're in, or Alice, if you're in, you can just, you know, project the paper so that we're able to move fast and swiftly. As they do that, anyone with any question, anyone with anything that maybe they'd like to ask before we begin? Anyone with any questions? Do we have any questions in the house? Anyone would like to ask something before we begin? Pius, I think you talked about the notice for when the exams are starting. I think we got enough notice, and I want to believe that you guys will also get enough notice. They don't really give you a notice this week, and exams are next week. They'll give you enough. They'll give you enough notice. So I want to believe that, you know, CLE will issue that notice at the right time, and all is gonna be fine. But at least you know when you know when they're supposed to start, even though it's tentative. At least you know when, so then you're able to prepare yourself. Anyone who can project the work for us? Anyone who can project the work for us so that we can begin? If you have a laptop, I think it's quite easy. To be quite easy. So the first part of this session, we are going to, yes, Dorothy?
I can project the paper. Maybe you give me a few minutes.
Oh, I think Absalom is already projecting, but thank you for offering. Yeah, thank you for offering. Okay, guys, so the first part of this discussion is going to be led by my good friend, Caroline. Caroline did her exams last year. He was with Angelo and the group, and she was able to pass her exams. She was able to do it. She's done it right now. She's moved forward. This is history for her. And I want to believe come next year at a time like this, we'll also have some of you leading us through this session, and it will just be the same story. So Caroline, maybe you can just say hello as you take us through the first part of the session. Please feel welcomed. This class is a good class, very, very, very active. Very, very bright, and they participate and they know what they talk about, and they're able to support their answers. This class is a good class, and I want to believe that we're going to have a good session today. Now, again, guys, let's just give her all the support that she needs. Let's be free. They usually say Article 33 of the Constitution, you have the freedom to express yourself. Just say what you think. Let's help each other. Let's answer these questions together. We are not here, the way we said, we're not here to give you answers, but we want to lead each other towards the right answer. So if you have a question in mind, if there's something that you want to say, if there's a point that you want to add, please, it's such a free forum. You can always just raise up your hand and say what you think. We might learn, something from you. I mean, who knows? We might just learn from you today. The laws keep changing, things keep coming in. Maybe we do not know everything. Maybe you've learned something that we do not know about, and we are ready to learn the same way you guys are ready to learn. Okay, Caroline, maybe you can just say hi. Okay, and the person who was projecting, Absalom, I don't know what's up. We can't see the paper. Let me just confirm if maybe she's having a few issues. Hello, Caroline, are you there? Or are you having issues? Because I can't hear you at all.
Hello, hi Daniel.
Hi.
I hope you can hear me well.
Yep, loud and clear. Take it away.
Yeah, I was making some adjustments. I'm sorry. Hi everyone.
No problem.
I'm Caroline. Yeah. Yes. Hello. I'm Caroline Gitonga. I did my I sat for my bio exams in March and successfully did so, and I'm grateful. Yeah, I attended Daniel's sessions last year, and they were very helpful. And I hope that we can able to give up in this little way. I'm going to help facilitate the first half of this paper, number 1, 2, and 3. And someone can please take us through number 1, please. Read through the question. Then we can start from there. Thank you.
All right, anyone can read?
Okay, I can do it. Let me do it to save time. Maseno Developments Limited have purchased a property from the Patel family. The property comprises 1 acre of land in Jaba Estate in Nakuru City and has been the Patel's family home for many years. Maseno Developments would like to develop 50 high-end apartments for sale. Construction is due to commence in March 2023 and complete in December 2024. You have been instructed by Maseno Developments to represent them in all legal deliverables relating to the project. Part 1, you have reviewed the title to the property and noted that the permitted use is a single dwelling unit. Discuss what your client should do to be permitted to develop multiple dwelling units. Part 2, Maseno Developments would like to understand how apartments are titled. The CEO recently attended a webinar on sectional properties but is unclear on how to proceed. Advise your client on the process of issuance of sectional titles for each of the apartments. Yeah, I think we can address that part first. So first things first, I think it's important to share some insights that can be used in any other paper or any other question, as I even tackle this specific question. First of all, in any exam paper, I think any line, phrase, word in a paper, in a question matters, is of some significance. So even the timeline that they give March 2023 and to complete in December 2024, for instance, really matters. And in our response, to make sure that we get all the marks, we have to make sure that we've tried to see how these fit or into a response that the examiners wanted us to deliver. So the first thing to address is what should the client do to convert these the use of the parcel of land from a single dwelling unit to multiple dwelling units. And the process is procuring a change of user. And section 50, the governing law is the Land Act, and you should, sorry, there's a Land Act, but now the specific law that regulates land use is the Physical and Land Use Planning Act of 2019 that makes provision for the planning, use, regulation, and development of land and for other connected purposes. And section 55 specifically, with regards to change regulation of development of land, gives the objective of development control, and you can, instead of using a lot of time looking at them, you can look at them. But one of them is to ensure orderly physical and land use development. And section 56 gives county governments power to undertake development control within their areas of jurisdiction. So in this case, it's the county government of Nakuru that would be involved in any processes and any regulation that may be relevant. And such a county government would have the power to consider and approve all development applications and grant all development permissions, etc. And section 57 of that act still goes further to provide that a person shall not carry out development within a county without a development permission granted by the respective county executive committee member. So I think the first thing you do is identify that first the client should procure a change of user and give some laws that provide for these, some sections rather, some provisions that provide for these, and that you give a very good base for giving your response. The second thing you do is now give the procedure that the client would have to follow through to get these relevant permission. And the first step that they do is procure the services of a physical planner. And these physical planner should be registered in accordance to the law. In these are this is the physical and land use planning act and the requisite regulations. So they should be registered. All professionals that are involved in conveyancing transactions, you should make sure that they're licensed or registered accordingly. So just before that, you should also note that the person who has the authority to procure or make an application for a change of user is the land proprietor. So the owner of the property is the one who should first procure the services of a registered physical planner, and then make an advertisement in 2 local newspapers of wider circulation, giving a 14-day notice for any objections or comments, and then make an application using Form PPA1, which application should be accompanied by a project brief or report that's made by this registered physical planner, and it should have the development plan, particulars indicating the purpose of the development, proposed use and density of that parcel of land. It also should be accompanied by a title document attached to the application documents, a comprehensive location plan, a copy of local authority payment receipt, and and then the application should be addressed to the town clerk of that particular county, who then, upon receiving, once the county government receives the application, it's required within 30 days to refer the application to the Director of Physical Planning for their comments. And such a referral may be made to other related government offices for their comments, such as the Commissioner for Lands, the Chief Engineer for Roads, the Chief Public Health Officer, and the Director of Agriculture. And the town clerk then, if there are no comments or if there are no comments, the town clerk issues an approval for the application for change of user in form PPA2. So for these conveyancing questions, you'll notice that most applications are made using prescribed form. Whenever you can remember the name or label given to the form, please give it. It may maybe give you some extra advantage, but whenever you don't, please say the prescribed form. You still get the marks. And so yeah, I was saying that the town clerk, after making these referrals and after the 30 day within that stipulated 30-day period, they issue an approval for the application in form PPA2. Then an announcement on the proposed change of user is advertised both in the daily newspapers and on site of the property. It invites objections from the public within a period of not less than 14 days. Upon receiving the development permission in form PPA2, the proprietor makes an application to the Commissioner of Lands for change of user. Yeah, so the Commissioner of Lands issues an approval or consents to effect change of user subject to payments towards surrender and grant of new title. Now, there's some process. I know it may not be, this is a bit too much for an 8-mark question, but I thought I should give the comprehensive procedure for what happens for knowledge, because I think something you can note about CLE, anything that's in the regulations or in the acts can possibly be tested, especially for conveyancing. So the first thing you do is, please, your land act, print out your land act. Please print out your land registration act. Please print out legal notice 278, which has all the prescribed forms for making applications. Please print them all out and read them. The Auctioneers Act, the Physical Planning Act, make sure you read them, because anything there can be tested. They did that during our year. They can do any other year. And basically that's what makes up the conveyancing curriculum. So please let those acts be your Bible. Our lecturer told that we should do it every day. We read 10 sections of the Land Act and some other act, and by the time you're doing the exams, you may not be totally familiar with everything, but once you see something, it will look familiar, and you may remember a point or two, which will give you an advantage. So I can proceed with what happens after the application is received by the Commissioner for Lands. Once the Commissioner receives the application, they can approve and set the pace for effecting into ownership documents. It's important that the Commissioner for Lands is involved, because once a change of user is effected, whether it's for a lease or an RLA title, a Commissioner of Lands has to be involved, because the deed plan will have to be changed with respect to the property, and the title may have to be changed. So it's important that you know why a Commissioner for Lands is coming into play. And once they receive this application, they assign it to a lands officer of the level of the chief lands officer on behalf of the commissioner, and then the commissioner's office sends a circulation letter seeking comments from the director of survey and director of physical planning. So remember, I've said a new deed plan may have to be issued. That's why the director of survey is being involved. And once the director of survey and physical planning and the director of physical planning get the circulation letter, they submit their comments through a licensed surveyor. So a licensed surveyor is a person who submits the comments of these two directors. So these comments are taken to the Commissioner for Lands, who then sends to the chief land officer. And then the officer compiles a ground report with feedback from the land valuer, a registered valuer, enhancing the land rate. And And with this, the property owner is allowed to proceed with an official search to ensure every detail has been captured in the file. And then the file is circulated vertically down to the chief land officer, to the principal lands officer, then to assistant commissioner of lands. And then the file now is mature to be tabled before a technical approval committee where issues permitting to the land and its change of user are issued and discussed and ratified, and minutes of the technical approval committee are then circulated to the deputy director of survey, who then forwards it to the commissioner for lands. So if there are no objections regarding the application, the file regarding this application is sent back to the lands officer, who handled it, to draft an approval letter on behalf of the commissioner of lands. So complete with any new conditions and demands to be met. Such new demands that may be stipulated include developing new deeds and calling for the property to be resurveyed. So if they give feedback that the property needs to be resurveyed, then that's exactly what the proprietor will have to do. And then, of course, this will be in accordance to the Survey Act, and I don't think we need to get into the details of that, but the survey process takes 8 stages that culminate to approval by the Director of Survey, where also a new land reference number may have to be issued for the property. And then with the resurvey and deed plans complete, the applicant fills up an application form to apply for new titles from the land registrar. I think, yeah, you should check out the legal notice 278. It has the application form for this. Then the applicant then surrenders the old title and the new deed plan to the registrar, who then files a deed file. Now, in any land, and let me say for any land reference or land title, apart from the title that you as a proprietor has, the lands office has a corresponding deed file with entries in respect to that property. So this is what a deed file is. So for instance, when you're making any transactions to land, regarding that, parcel of land, when you go to lands, they have a copy of, the entries that you have in whatever is called a deed file. So after this, the registrar then proceeds to process a new title from the property with a new user included and the new attendant conditions, if any. And if it was a certificate of lease, if the land rate has been enhanced after the resurvey or something like that. So it should also be noted there are certain consequences for proceeding with a development and a change of user has not been procured. 1, the government may reprocess the land. 2, the government may require the owner to restore the land to its original condition. There's some case law for that. Ocean Freight East Africa Limited versus Ismail G and another. It's a 204 case. You can check it out in Kenya law. So with respect to the statement that construction is due to commence in March 2023 and complete in December 2024, it's significant in that upon approval for a change of user, a developer has to commence construction or development within 2 years after getting the approval. So specifically, after they get the approval from NEMA, they should commence development within 2 years. So it's important to capture that their timeline is quite in line with the law, that the development should take place within 2 years after getting the approval. I think we've comprehensively covered that part. Now, the second part is they'd like to understand about sectional titles and how to obtain them.
Caroline, I think
yeah?
we might have, I think there are a few questions, and I think they'd also, I don't know if you're able to share that whole process with the group.
Yeah, I can try turn it into soft because I made some short notes in my notebook. I don't know whether they can read from my notes. I can try maybe convert it into some soft copy and share, if that's okay.
Yeah, at least. Yeah, I think that would help. Then I think Pius has a question. Pius, go ahead.
Go ahead.
Thank you, Caroline, for that wonderful presentation.
Thank you so much.
Part of the question. There
Thank
are
you.
two things I would want to seek clarification on.
Okay.
Can you hear me?
Yeah, I can hear you.
Can you? Yes, thank you. So the first question is on the issue of town clerk.
Sorry, on the issue of?
Town clerk.
Oh, the town clerk. Okay.
Then and then the commissioner for lands. Because I think commissioner for lands may not be there in the current setup due to the presence of the National Land Commission.
Yes.
And then if you look at the physical planning act, the Land Use and Physical Planning Act, if you look at the procedure for change of user, they're saying that the standard procedure, of course, in section 58, should be through form PLUPA. That will help in the pre-application stage, because they have 3 stages. They have pre-application stage, application stage, and the last part, which is now consideration stage. They call it the approval, refusal, or deferment. So I don't know whether you could comment on those.
Yeah, I can comment. I can comment on the issue of. I can comment on the issue of town clerk and the commissioner for lands. We have now the chief land registrar, right? And in the counties we have the commissioners and the respective committee executive the executive members. So I think, sorry, I interchangeably use that, and you can note the changes since 2010. We have the so where I mentioned the count clerk, you can replace with the executive members of the county. And where there's I've mentioned the the commissioner of lands, you can replace with chief land registrar. I think I confused the 2 regimes. I'm sorry. The other question is on the form. I was, as you were just asking the question, I was trying to access the act.
The form PPA1 is still in use.
Sorry, yeah, the approval form there is PPL2. I'm sorry. Thank you for that.
I'm sorry. Thank you for that.
You are correct on the forms. The only addition is that before you apply, what they are saying is you must first of all make an application in the pre-application stage using a registered physical planner, using that form PLUPA. You make an application for change, and then you conduct for change of user, and then you conduct a meeting.
A meeting with?
You conduct a meeting with the respective planning authority at the county level. to gain an understanding of what to expect and the permissible land uses on their piece of land.
I'm not quite getting it. I mentioned that you should first procure the services of a registered physical planner. What am I missing?
Okay, what I'm saying is, in securing that service for the physical planner, they are saying that that physical planner should help you in the application under Form PLUPA for permission. And then once you get that permission, then you need to conduct a meeting, a pre-consultation meeting with the respective planning authority. And then prior to making that application, you first need to advertise.
Yeah, I said first you need to,
yes.
yeah, you need to make an advertisement, and then even after the approval is given, the announcement for the proposed change of user is advertised.
Yes, so the confusion that I have, that I wanted you to also address, is this form PLUPA that comes before PPA1.
What you mentioned section 58, right?
Yes. If you could help us maybe
Subsection?
understand the use of that form.
What subsection?
It's section 58 of they are talking of section 58 through to section 61.
Yeah, I'm not sure about that. Honestly, I think it will take a while to go through that. But what I know, the reason for engaging such a qualified person in accordance with section 59 is to ensure that all documents, plans, and particulars, and remember that this physical planner is going to execute some of these documents and plans before you lodge them to the county executive, to the county government for to tender in your application. I can't speak to the inclusion of that form, but all I know is that it's the significance of engaging the registered physical planner from the onset before you even make the application, because you'll have to sign the plan, the project brief that comes with the application, and also engage him all the way to even when you take the application to the commissioner for lands. So I think that's what I can say.
Thank you.
Okay, thank you. George, please.
Okay, good evening.
Good evening.
Thank you for leading us well so far. At least I'm getting something. At what point? My question is: at what point?
Yeah.
At what point is do we involve the NEMA and such kind of authorities?
Yeah, you engage NEMA. Yeah, the approval by the county government through the county executive committee, and also by the national by lands is subject to obtaining a license for the development separately from NEMA. So you can only obtain a NEMA license after getting approval from the county government and at lands. So after getting to these two approvals, you apply for a license for the development. Whatever we were acquiring from the county government and lands is approval to change the user of the land from a single use to a multiple use. So a separate license has to be applied for in respect of the development from NEMA. and this is after getting these approvals. So these approvals are subject to obtaining a license from NEMA. And after getting the approval from NEMA, you need to commence construction within 2 years from the date of approval. Is that okay? Okay, thank you.
Thank you. I've understood.
Yeah, thank you. If there's no other question, we can proceed, please, because of time. Yeah, in a question, please. I can see a hand up, please, to save on time.
Yes, maybe you can't see the name, but no problem.
Yeah.
I'm speaking on the point raised by Pius. He mentioned that he may have been referring to something. Maybe he can advise. But I'm also persuaded by his point that if you look at the regulations, one of the regulations under the Physical Planning Act, the Development Permission and Control Regulations, in terms of form, I think there is an expectation that the form itself has changed. And so currently there is the form he was referring to, which is in the first schedule of that regulations, form PLUPA/DC/A1. You'll find that there is a form which I think should have replaced the one that you mentioned.
Which one?
In terms of PP, you mentioned PP1 or PP1.
There is a. Okay, just a minute. There are two forms. Let me just confirm. Yeah. That's right. That's right. That's right. It's PPLU, right?
Yeah, PA.
Yeah, PPLU. That's right. So please, sorry, I'm sorry. Please note, please, everyone, please note that. And also the reference to the town clerk, to the county executive committee member, and also the reference to the land officer, to the land commissioner of lands, to the land registrar. Thank you for that. And please, we can go to the second one, the titling of sectional properties, which in this case is covered under the Sectional Properties Act. And when also you think about sectional properties, this is A or B, you can also think about fractional ownership and fractional and timeshares, which also emanate from such ownership, which will, I think, Daniel will discuss these. I think it's in another question. Yeah, but you should think about them in the same light and try to see how they coexist, or which stems from what, or such correlations. I think Daniel will handle that as he handles the other questions. Because of time, we can go straight into sectional properties. Of course, the Act defines what a sectional property is, and the rationale for it. And the rationale is to only confer ownership or certificates of title for leases exceeding 21 years. And I think it's important you check out the Land Act and its definition of what a long-term lease is. The Land Act defines a long-term lease as, I think, if someone can confirm, as a lease that exceeds 5 years, because now the short-term leases under the Act are leases that are below 5 years, that don't exceed 5 years. So I don't know, you can try contrast these and see how it coexists. Also, there's also the issue when you talk about sectional properties, the issue of management companies that existed in the regime of long-term leases vis-a-vis the corporations, management corporations. Yeah. And you have to look at the elements, of course, that there has to be more than one unit. It can be held in freehold and leasehold, because someone could have a large piece of land and say they subdivide it into parcels of land, especially for these gated communities that they try to sell to the real estate developers try to sell to us. These are gated community with all these amenities, blah 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 blah. There's controlled development. The structures have to conform to certain requirements. So you can try to look at it in that broad sense. It doesn't have to be apartments only. And there must be a sectional plan, illustrating every single unit, the layout, the description of sectional properties. It has to be registered. There's no unique registry that has been created for this, because there is the districts at Nairobi. There's the district land registry. There is the inland registry for leases and other regimes. There's the government land registry that's also at the house. So you try to look at these, despite the fact that this type of ownership was created, there's no unique registry that was created for it. And the certificate of titles I issued, I'll try to redact one sectional titles of some information, and perhaps I can share with Daniel and try to share with you. But this one, it's for an apartment, so it's a certificate of lease that was issued, and it has the apartment number as the title number. So basically it's a certificate of lease. For apartments, it's a certificate of lease that's issued. And if it's maybe for a freehold property, a section of the freehold property, it's a certificate of title that would be issued. And of course, you have to consider that what happens once a sectional plan is registered, the mother title is closed and new title files for each unit are opened in the registry. And then the common property is held in tenancy in common. And now you have to think of it is it distinguished what each person owns, when apart from the common area, such as, does it show the number of maybe parking spaces that each apartment owner owns, and such and such and such. And of course, you have to consider that the register maintained in sectional properties is the same register maintained under Section 7 of the LRA. And of course, the sections of the title are those described in the legal notice 278, because it has an encumbrances section and an ownership section, and a proprietorship section. The first section is the property section, proprietorship section, and then there is the encumbrances section. It has all those three sections. And also, use and management of common properties governed by bylaws, and titles are issued under LRA, as we've earlier mentioned. After registration of all units, all dealings should be in accordance with the LRA. No more than one unit may be referred to in one register. So each unit, different register. Of course, once all units have been registered and the mother file closed. So now we've mentioned a sectional plan. What is it? It's prepared by a registered or a licensed surveyor. You have to give the surveyor the proof of ownership as you request for a sectional plan. It's extracted from a building plan that has been approved by a county government. It shows the surveyor proof of ownership. So to get a sectional plan, or rather a sectional plan has to have a heading, this is a sectional plan for blah, 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 blah. It has to have a georeference, which is a reference of objects using a specific reference, interior, exterior, etc. It has to have a statement containing particulars to identify the piece of property, such as the parcel number. it has drawings. It has to have drawings illustrating each unit and distinguish unit by numbers, such as B31, B42. It has to approximate the floor area of each unit in square feet. That's mostly. It has to have been endorsed on it a schedule specifying in whole numbers the unit factor for each unit in the parcel. And it has to have been endorsed on it the address that at which documents may be served on the corporation, and it has to be signed by the owner of the mother title and signed by survey unit that issued it. And so what is the question actually asking us? You should advise your client on the process of issuing sectional titles for each department. So the first step is to procure the services of a registered or licensed surveyor to prepare a sectional plan. And now I've discussed what should we include in a sectional plan. So after you've said that you should procure the services of a licensed surveyor to prepare a sectional plan, you should say what should be contained, what are the requirements for this, and what you should give the surveyor for them to be able to prepare a sectional plan. So you should also prepare the unit owner, but no, it's not the unit owner, sorry. It's the developer. It's the developer that prepares the application for registration of corporation according to Section 17 of the Sectional Properties Act and in Form SPA 7. You can confirm it's Form SPA 7 and make a list of owners of each unit. As we've said, the sectional properties applies where there is 2 or more units. So the developer or the applicant should describe 2 or more units, and they have to prepare these documents to accompany the section plan. Certificate of a surveyor, which illustrates the external surface boundaries, where the building sits, where the unit starts and ends, the beacons, if it's a parcel of land, etc, etc. It has to show the structure, etc. They also have to have a certificate from the county government. This is why I started with a description of the general overview and what should be there in acquiring a sectional plan, because it goes into details of how the county government and the surveyor come in. It has to, after you've prepared a sectional plan through a registered surveyor and prepared an application for registration through Form SPA 7, and also after you've prepared a list of owners of each unit, which should have a list of 2 or more units, and prepare documents which includes a certificate of a surveyor, a certificate of a county government. The next process is registration of sectional plans, which is under Regulation 9 of the Sectional Properties Regulation. It should be accompanied by the original certificate of title or lease to that parcel, to the mother parcel, bigger, broader parcel, an application for the registration of the management corporation. Now, one difference between a management corporation and a management company is that under the old regime, a management company would have to be incorporated, would have to be to become a legal person, to have legal personality. But now a management corporation is a creature of statute. It's being created by it's a creature of the statute. That's one major difference between those two. In the old regime, you'd have to incorporate a whole management company. But under the new statute, there's no need to go through that company's procedure. And the other after this, under Regulation 9, for the registration of sectional plans to happen, you have to have submitted the original certificate of title or lease and an application for the registration of management corporation. After this, the registrar closes the register of the parcel described in it upon the registration of the sectional plan and open a register for each unit. You see why we need to have 2 or more units for this to happen. Otherwise, it would be just the normal registration of interest in land. So if it's freehold, as I've mentioned, it will be a certificate of title, and if it's a leasehold for apartments or or other dispositions, it would be a certificate of lease. Yeah, after registration of the sectional plan, you submit it to the county government under Section 9(2) of the SPA, and now regarding the management corporation. You remember you submitted it at the point where you are registering a sectional plan. You can't have a sectional plan without a management corporation. That is why when registering a sectional plan, you submit an original certificate of title and an application for the registration of the corporation. So the management corporation manages the sectional unit to the extent of use of common areas. And on registration of a sectional plan, there shall be a corporation under the name, the owner's sectional plan number, blah, 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 blah. The number to be specified being the number given to the plan on registration. The registrar issues a certificate of registration of the corporation, and then the corporation consists of all those persons who are owners of units in that development. And such a corporation shall have perpetual succession and a common seal. And the Act also mentions its functions under Section 20, which are examinable, and also termination of sectional property under Section 55 by unanimous resolution, substantial total damage, compulsory acquisition, Section 55, examinable too. And there are also certain agreements that may be entered into, such as recreational agreement, management agreement, how to ensure that the building is maintained to a habitable condition. Also, the management company that manages the building, and management corporation where every member has shares, and it's a creature of statute. So I was making comparison between these two, and I think that's very much the process, where I can quickly recap where you register a sectional plan by procuring, you prepare a sectional plan by procuring the services of a licensed surveyor. We prepare an application for registration of corporation, of management corporation under Form SPA 7, a list of owners of each unit describing 2 or more units, prepare documents to accompany the sectional plan, certificate of the surveyor, certificate of county government, and then now the registration of the section plan under the Regulation 9, which should be accompanied by original certificate of title lease, application for registration of the corporation. Is that okay? I see no questions and thumbs up, so we're good. Yeah. The next question. Can someone take us through number 2 or nisome bado?
I can read, and then you.
Yeah, thank you. Thank you.
So
please read.
Bring it up.
Yeah.
Erickson is newly married to his childhood sweetheart, Angie. They have been staying in Mihango in Utawala. He has decided to find an apartment in Lavington to live with his newly wedded wife. He has been lucky to find a 3-bedroomed apartment in Lavington owned by Arthur Johnson. Arthur Johnson has agreed to sell, and Erickson has agreed to buy the apartment for 18 million Kenya shillings. Erickson has made arrangements with XYZ Bank for financial accommodation of the entire agreed amount to enable him purchase this apartment number B5, erected on LR number 119/537. Arthur Johnson has been referred to you by your former pupil master to handle the transaction. As Arthur Johnson's advocate, proceed to draft the relevant initial legal document that will govern the relationship between Erickson and Arthur Johnson. Thank you.
Okay, now we've been told that they've decided to find an apartment to live, and they've found a 3-bedroomed apartment in Lavington. It's not just to fill out space that they've said it's a 3-bedroomed apartment. Whatever you draft should reflect these. And you're told that Ada has agreed to sell and Erickson has agreed to buy. So this is also something significant, and it's an apartment for 18 million Kenya shillings. They've made arrangements with a bank for financial accommodation for the entire agreed amount to enable him purchase this apartment. So this is a fully financed purchase. Ada has been referred to you by the pupil master to handle the transaction. Proceed to draft the relevant initial legal document that will govern the relationship between Erickson and Ada Johnson. Now, this is a question that can make you lose the entire 6 marks. If you don't identify the right documents that you're going to draft, you're lost. You lose all the marks. Now, the initial legal document for any dispositions in land, especially such a disposition, is an agreement, is a contract. This is the contract bit of a transaction. It's an agreement for sale. It's not a lease, it's an agreement for sale. After an agreement for sale is drafted, you can now draft a transfer to facilitate the change in ownership, or a lease to show possession. The possession document, to transfer the interest. And since they're saying it's the initial, it really gives, that's the catch of the question, really, because that's the first one. This will show how parties are agreeing, how the terms the parties have agreed to adhere to, and whatever terms will guide the transaction. So in a sale agreement, the LSK conditions of sale 2015, if you please could get a copy, you get a sample agreement for sale that has all the major basic clauses. A sale agreement an agreement for sale can be 5 pages to 100 pages, ranging from the terms that the parties want to be included in governing the transaction, and whatever rights and obligations they want to include. And of course, the vendor's advocate or the purchaser's advocate can draft the agreement. But I think in most instances, the vendor's advocate gives a draft, passes on a draft to the purchaser's advocate, and they go back and forth, sharing the draft, tracking the changes until the parties agree, come to a common ground on the terms, and then in the contracts, and then after the negotiations are over, they can now execute the agreement, the terms of which are binding to the parties. And I think in this case, we'd have to identify what clauses are crucial to our agreement. The first thing is the title. We have to, when drafting this agreement, we have to have the title. It's an agreement. It has to identify what type of instrument it is. It's an agreement for sale. Between the vendor and the purchaser. So the vendor is the person who's agreed to sell, and it's Ada Jackson. So Ada Jackson, the vendor in brackets, and Erickson. We just have Erickson, as the purchaser, And then now you identify the property, apartment number B5 as part of the development, all erected on land reference number 119,537. Whatever part of Lavington it is, you're done. You can now include even the details of the in your cover page. You can include the details of the advocate who's drafting, their admission number, their PC. It usually appears in the cover page. You can now go to the agreement itself, which you say this agreement made between Ada Jackson, Oz Johnson, and Erickson, or Ada Johnson of ID number dash 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 and PO box dash 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 on one part, and and Ericsson of ID number blah 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 and PO box dash dash dash. Now that clause is important because it identifies the parties adequately by providing their names, their ID number, and their physical address. And so after you've successfully identified the parties, you can now describe the property. The vendor has agreed to sell, and the purchaser has agreed to, buy, the apartment number B5 erected on land reference number 119,537, located in or situated in dash dash dash. You give the full description as even described in the title, in the lease. Sorry, in this case it's the lease, because if it's an apartment, we have to find the either the grant or the certificate of lease for this particular piece of land upon which the development is made. After describing the property, we now talk about the purchase price, and you can say you identify the purchase price as 18 million, and now also the LSK conditions of sale identify the deposit as 10%. The parties may agree to a more percentage of this deposit, but now as a baseline, you can see that the deposit shall be 10%. Is 10% of 18 million is
1.8.
Yeah, 1.8 million. Yeah, then you identify you identify that that maybe the deposit is payable upon execution of this agreement, or whenever the parties have agreed. The parties have autonomy, despite the LSK having some baseline agreement upon which parties can adhere to, and the parties can always agree. They have autonomy to agree. There's freedom of contract. Yeah, so you identify that the deposit will be 1.8 million, payable maybe if the parties agree upon execution of this agreement, and the balance of the purchase price, which is you identify, shall be payable on a certain date or upon the occurrence of a certain event that is totally determined by the parties. So you was drafting this agreement, you have the freedom actually, but what they wanted to see is whether you can identify these important clauses. All these, of course, so we've talked about, and obviously the agreement describes the advocates for the parties. The vendors' advocates shall be Messrs. Daniel and Co. advocates, and the purchasers' advocates shall be, George and Co. advocates, and you give the address and the details. Or you can even actually identify an advocate shall be, Oyo of George and Co. advocate, of Messrs. Oyo, Peter of George and Co. advocates, or Suzanne, Messrs. Suzanne of, Suzanne of Miss Suzanne and the other name of Daniel and Co. advocates, and you give the addresses. And after you need the advocates, we've talked about the purchase price, the property, identifying the property. We've talked about the purchase price. You can also, now another important clause in our agreement, you should have a clause allowing for financing of the entire purchase price. Now, if a sale agreement doesn't allow for financing of the purchase price, there are certain implications. One, the vendor may rescind the contract if they are not agreeable to that. if it is a cash transaction, cash sale purchase. Number two, the vendor may impose a certain interest with regards to, you know, that whole scenario, such that they'd want a certain interest imposed on the amount, because a financed purchase would ideally take more time than a cash sale. This is because there are undertakings involved, as you've learned in class, and some bankers would have, you know, the financials advocates, you know, perfect the securities before they can release the purchase price or the balance of the purchase price. So it's important that this clause is there and you include such terms that the vendor maybe could impose some interest, or it's just, you know, they just agree with it with no strings. While contracts usually have more clauses, a contract could also have after the some part on definition of terms. I think this was really the most important part of it, that you identify these clauses. And also you should have, maybe you could have included a clause on what the purchase price is, and or who parties, the governing law, which you could say is the LSK Conditions of Sale of 1989. I know I'm aware there's a 2015 conditions, but they have never been gazetted, or, you know, there has never been any formal approval on them. So I think that's basically covers that question. An agreement of sale can have as many clauses as they get. You know, there's also another key, I see it's an apartment, there's another key clause on titling. The vendor should give directions as to how the titling will go about. Is it a sectional title or the long-term lease way? I think these are important terms that should be addressed. Payment maybe of a service charge, and or if there are any other costs, direction on the common places, yeah, you know, such details. As I said, it can range from a 3-page agreement, a 4-page agreement, to a 100-page document. All depends on the clauses that are being included. Again, please go to the LSK Conditions of Sale and see the outline of an agreement for sale. And it can always, you just have to check the unique conditions of situations of your client and see what conditions, what clauses you can incorporate, and what rights and obligations you can add. Yeah, I can see a hand, I can see them, please.
Yes, my name is Frank.
Mm-hmm.
I don't know if you can hear me.
Yeah, I can hear.
Yeah, I had 2 questions, but the first one you've basically addressed it.
Mm-hmm.
I was to ask about being an apartment, there needs to be a clause touching on the service charge and the manner in which the common places, the common areas are going to be handled. My other question is about the issue of XYZ Bank financing this transaction. Basically touched on it, but there's no clarity on which specific clause you can introduce.
It's a clause on financing. A clause allowing for financing.
So you will basically say that this clause is financing, and you'll be saying that this sale will be financed by XYZ.
No, you just it's a clause. You can title it. It's a clause allowing financing of the purchase. This agreement allows or permits, I don't know what wording, allows or permits financing of the purchase price. But you can even identify, you know, the bank, XYZ Bank. Yeah, for the entire amount. You have to show what amount is being financed. And in this case, it's the entire 18 million, which hardly ever happens. But yeah, sometimes the bank can finance the whole amount. Most of the time, the bank finances the balance of the purchase price or a part of it.
That is where I was going, because I realized that most transactions, the purchaser will be required to pay at least the deposit, which is normally 10% of the purchase price.
Yeah.
The remaining amount is going to be financed by an institution. So when you're bringing in such a clauses in a sale agreement, I believe you have to be very tactical and careful on how you structure such clauses. That is where I was clarity on perhaps if you're being told that the bank will finance a certain percentage of it, how will you bring the bank into to such an agreement, other than saying that the bank will issue a professional undertaking that it will finance the purchase price once ABCD has been done.
That's exactly it. After saying that that the balance of the purchase price shall, or the entire purchase price, you've already defined it uko juu, and it's 18 million shall be financed by this bank, subject to, and you can impose certain conditions to cover the vendor, such as there will be a professional undertaking, one from the bank, two from the vendor, one from the bank itself, two from the financiers advocate. Remember, for the bank to issue such a facility, they'll have to perfect the securities first. So the transfer will have to have happened, and therefore they'll have had completion documents despite the fact that no money has been paid for this property. So there has to be an undertaking so that the vendor can release the completion documents to the financiers advocate for them to perfect these securities, so that now they can release the agreed amount. So I think you give this clause, then you give what it's subject to, these undertakings, and maybe any other condition. Remember, there's freedom of contract, there's party autonomy. Whatever the party agrees, the party agree to. If they agree that, if the vendor agrees that this amount, that he's willing to have the entire amount financed, who are we to disagree? If the vendor says no, why no? And in this case, of course, we don't have that privilege, since already the facts have been laid out for us. If the scenario says the entire amount is to be financed, the bank has allowed that, we can't question that. Yes? Yes, please.
Excuse me, I have a question.
Ask. Please
okay,
ask.
Since the bank is financing the entire amount, well, what if we introduce encumbrances clause and charge the property in favor of the bank?
No, that doesn't happen in the sale agreement. That happens in the financing part. The property is being sold free of encumbrances or whatever. We are assuming that there's no encumbrances given in the scenario. But whatever happens once the issue goes to the financiers advocate and they're perfecting the securities is after the agreement has been made. At this stage, we are only making the agreement. Now we've just gone ahead to foresee what's going to happen there. We are just in the initial stage, what legal document is coming into place. So at this point, the property is free of that encumbrance. The encumbrance will happen after the transfer, or whatever it is, if it's a lease, whatever. We are still at the point where we are defining the terms. I hope it's clear. Yeah. Okay. Yeah. Next question, please. Yeah.
But I'm still asking a question. What will be the danger of basically not talking about XYZ bank? Because at the end of the day, you will have a separate arrangement with the bank to issue a PU to the vendor, so that the transaction is complete. So from this agreement, there is no point penalty, or nothing will happen, or the transaction will, the agreement will not be rendered void if there is
actually
no,
it can be rendered void. Actually, sorry, can I please stop you? Actually, the agreement can be voided if the vendor isn't agreeable to that term of financing. So it's a serious deal that the agreement has this clause allowing for financing, and the degree to which it's being financed, it's also crucial. Actually, people are petty out of here. People out here, people are petty. If a term is not agreeable to them, they can void the agreement and they no longer want to be part of it. It's actually important that it's captured, that it allows financing from this financial institution if already the purchaser has identified the institution. And to what extent are they financing the purchase? It's very, very, very important.
All right, I think.
Yeah. Okay, Daniel, you can give more more clarity on that.
Yeah, I think maybe there's some pushback from George and the rest, because I think for them they're talking about conditions, and but what they're talking about is encumbrance. And I think, as you stated clearly, we can have conditions as to when the payment will be made. Yeah.
Yeah.
But we can't have encumbrance, because at this point we're not talking about encumbrance. Encumbrance will come up later. So George and the rest, the guys who are asking, you can cover that under conditions of payment, conditions of paying the purchase price. You don't have to have an encumbrance clause, because at this point we're not talking about encumbrance. So the conditions are what is going to cover the charge that you guys are worried about. And what you'll be saying is the amount shall be paid by the bank after this and this and this has happened. Simple. So there's no need for an encumbrance clause. So that would cover you in relation to the encumbrance that you guys are worried about.
Yeah, because at this point they haven't even been financed. The parties are just, including the terms that they would like the that sale or purchase to be subject to. They're still at the point where they're agreeing. We're making documents that will guide the transaction. Okay, we can go on. Please, can you scroll down to number 2? Okay. Okay. Someone, can you please read for us? Please, kindly.
I can still read.
Please do.
Please do. Prime Property Limited is the registered owner of the leasehold property known as LR 500 12998, located within Nakuru City. The property is located in a busy part of town and developed and well fenced with barbed wire. The annual rent payable is peppercorn on demand and is for a term of 99 years from 1st November 2001. Please, could you bring up the other part of the question? Thank you. So the company has been approached by Albert, who proposes to utilize the said property as a parking lot. The company approaches you for legal advice on the transaction and has informed you as follows. 1, the company is hesitant to have the use of the defined premises for a period in excess of 1 year, but may be subject to renewal for a similar term. 2, the company prefers that Albert collects the daily parking fees and deducts an agreed commission fee from the revenues collected. 3, the company prefers that Albert maintains the parking lot in a good condition for the entire period and keeps proper records and books of accounts at all times. Question A, explain 2 possible ways that you may consider in structuring the transaction between Prime Property Limited and Albert, noting the pitfalls of each one in protecting the interest of the company. B, explain how you would go about the transaction to ensure that it is not a controlled tenancy. And C, Albert requires that a rates clearance certificate be furnished before he can proceed with the transaction. Advise your client on the import of this statement. Thank you.
Okay, could someone please give us an idea of what they think would be the response for that first question? Possible ways of structuring the transaction. Someone, please. Please. No idea. Just say whatever you think could be the response.
Well, let me start by saying they can license the property. So someone else can also add another one.
Okay, what about a license? Okay, yeah. I can't see your name, please. The person with your hand raised.
Oh, yes, it can also be a short-term lease.
Okay. Oyo. You
Yes.
mentioned a license. What are the pitfalls of protecting the interest of the company using a license? Oyo, please.
Yeah, I would seek some guidance on that.
Okay. The other lovely lady who spoke about a lease. Could you tell us, how the company's interest would be protected using a lease? A short-term lease in this case. And why a short-term lease and not a periodic lease?
Okay, so short-term lease is normally for a period of 2 years or less, I think. So that would satisfy the first condition whereby.
Sorry, how many years?
2.
Short-term lease. Okay. Go on, please. Remember, we're only looking at the interest of the company. Yeah, you're in the right track.
Okay, so the first condition, the company is hesitant to have the use of the defined premises for a period in excess of 1 year. So my understanding is that they want these premises to be used for a period of 1 year or less. So when they use short-term lease, then that would protect their wish. Yeah. Yeah. And what else? The third condition, keeping it in a good condition. So the responsibility of
over leasee.
Yes. That's all I can say for now.
Yeah, thank you, Donna, and thank you, Oyo. You're actually on the right track. The first. Yes, sorry, Hassan.
I think the right word should be sublease and not lease. Since
why?
The property already held on a lease, they can only sublease. So I think prime property should enter a sublease agreement with Albert.
Yeah. Okay, I heard you. You're all on the right track, and actually, that's why I want us to look at the definition first, because the definition guides us. You're actually all right in some way. Section 2 of the Land Act defines a lease as a grant with or without consideration by the proprietor of land of the right to the exclusive possession, not the phrase exclusive possession of their land, and includes the right so granted and the instrument granted and the instrument granting it, and also includes a sublease but doesn't include an agreement for lease. However, Section 2 of the Land Registration Act defines a lease as a lease or sublease, whether registered or unregistered, of land, or a short-term lease or an agreement to lease. I don't know. We'll go. Maybe you can have a debate as to of where now an agreement for lease lies, because of those two statements, but our core business is that a lease includes a sublease. So Hassan, I hope your concern is put to bed. Also, what type of lease is this? Is it a short-term lease? Is it a periodic lease? A periodic lease is for an indefinite period of time, but now since these people want to consider having a lease for 1 year, then from 1 year they can review the terms and renew as per their agreement. It's a short-term lease as per Section 56 of the Land Act, since a short-term lease is for a definite period of, though indefinite, the lease may be terminated by the lessor or the lessee. So this is perfect. Please, in your response, make sure you include these sections if you remember, or just the act. But please, if you remember the section. And two, there's consideration. They're considering a commission for every payment collected daily. There's also fixed premises. We've also been given the land reference for that plot. There's a fixed term, the 1 year, which is subject to renewal. There's also exclusive possession that will be granted to the lessee. So also there's the rights and obligations which are captured in the written agreement between the parties, which now the issue of maintaining the parking lot in good order, all those clauses capturing the rights and obligations can be captured, so the company can be safely protected. The other document is a license, as mentioned by Donna, and a license doesn't, unlike a lease, it doesn't confer exclusive possession to the second party. Now, in this case, will be the licensee. And a license is permission given by the proprietor to do some act in relation to the land comprised in the lease, which would otherwise be trespass, but doesn't include an easement or a profit appender. And a license, as I've mentioned, no interest in land is created, unlike in a lease, and a license doesn't have to be in writing. Please correct me, but I think a lease should be in writing, has to be in writing. But a license doesn't have to be an agreement, doesn't have to be in writing. And so how would a license protect the interest of a company, of the company? One, it'd show permission given by the company to Albert in respect of using the property as a parking lot, in utilizing the property as a parking lot. One pitfall of a license is that now when you look at the company, is that it may not be in writing, and it may not define the obligations of the parties. And a license also, what's another pitfall of a license? I think those two suffice for a license. And for a lease is the lack of flexibility. Sorry, Daniel, in just a minute. The lease is lack of a flexibility such that in that 1 year, termination would have to be through a notice. Unlike in a license where they can terminate, they can just terminate. It doesn't have to be notice. Another issue is, another pitfall would be in respect of, please you can contribute even as I brainstorm. Yeah, we've talked the issue of term for a lease. Derogating from that would be an issue unless there is notice or agreement between the parties. But for a license, it would be more flexible, especially where a license is not in writing, because it doesn't I don't know about the definition of a term, but a license is just permission. There doesn't have to be a defined term. And then the issue of rights and obligations that the company wants to impose. So for a license, that will be more difficult, unlike in a lease, which clearly stipulates the rights and obligations of the party. Yeah, Daniel, please.
Yeah, also looking at it from, the company's side, A license only gives Albert the right to use the parking lot, yes, in a way that if the permission was not given, then Albert would be trespassing. So it doesn't give Albert exclusive possession, meaning the company can still go into that land, do things here and there. That's an advantage. They're not totally
But we are looking at pitfalls in respect to protecting the interest of the company. We are not giving them legal loopholes.
Yeah.
We are not giving them legal loopholes. We are seeing the downsides that the companies may face.
If they give a license, that is, yeah.
Yeah, if they give a license. And one of them I was looking at it, the rights and obligations, because a lease would clearly stipulate them. And for a license, it may not necessarily do so, especially where it's oral. And the issue, yeah. And another pitfall they'd have is with regards to the issue of the term, in case again they give permission that's not qualified. And then, but for a lease, I'm sure some of the pitfalls they'd have is they can't quite wake up one day and terminate it. They'd have to give notice and the parties would agree, or as dictated in the lease agreement. Another pitfall they'd have is the issue of consideration. They'd have to stick to that consideration unless the party agreed to, or subject to some other conditions that they may show in the list. So it's the lack of a little flexibility, the issue of flexibility in respect of those two. Yeah, please, Daniel.
Yeah, but again, you do realize that both, just to contribute again to the discussion,
yeah,
both can either be written or not written. If you look at licenses, I don't know if you've seen some of them. They could be for 1 year, but they're actually written. So in both instances, actually, both of them can be written. But again, there's that option of not having them, written in words, because it's just for 1 year, so they can also be oral.
Exactly.
So I think we also have to look at it from two sides. Then I think, guys, you can also contribute to the pitfalls. Caroline, you're doing so much.
Yeah, so I see people just keeping quiet, and I'm like, okay, let me just say it. But it's okay. It's good that you express what you're saying, because once you say something and you contribute to something, it's hard to forget that concept. I tried and tested method. Contributing really helps. Okay. I wish I had the autonomy to call out names, but since I don't have, and ask questions randomly, I can't. So I'll just go into the next question. Explain how you'd go about the transaction to ensure that it's not a controlled tenancy. It's such a question. It's easy to get marks, because the first step is to identify what's a controlled tenancy and the governing law. So a controlled tenancy, what is it? What does the law term a controlled tenancy as? Donna, Oyo?
Yes.
What's a controlled tenancy?
So it is a tenancy whereby normally it doesn't go for more than 5 years. The term does not exceed 5 years. Then the termination is on breach. And let me get the third one. Someone can help me with the third one.
Writing.
Yeah, it must not be in writing, but it can also be in writing.
It should be in writing. Yeah, thank you. You're on the right track. Yeah. Yeah. Section 2 of the Landlord and Tenant Shops, Hotels and Catering Establishments Act defines a controlled tenancy as a tenancy of a shop, hotel, or catering establishment which hasn't been reduced in writing, or if it has been reduced into writing, is for a period not exceeding 5 years, sorry, contains provision for termination, contains provision for, contains or doesn't contain provision for termination otherwise than for breach of contract, or it can only be terminated on the grounds of breach of contract as said, and there can't be a controlled tenancy in which the government, the county government, is a party to. So the reason why I corrected you, Odwar, is that if it's in writing, that's why the issue of the period not existing 5 years and the issue of termination comes in. So it's either not in writing, or if it's in writing, the other conditions follow. That's why I corrected you on that. That's basically it. That's it. It's a question that was tested the year before us, this year, and maybe next year. Albert requires a rates clearance certificate be furnished before he can proceed with the transaction. Advise your client on the import of this statement. Remember, Albert is the person.
Sorry, Caroline.
Yep.
So how do you make sure that it is not a controlled tenancy?
So you make sure it's not a controlled tenancy by making sure the lease period doesn't exceed 5 years. No, it's the opposite of what a controlled tenancy is. You have to begin by knowing what a controlled tenancy is, so that now if I don't want it to be a controlled tenancy, I make sure it doesn't fit this criteria. So I make sure it doesn't exceed 5 years. I make sure that the only provision for termination is on breach of contract, and I make sure that the government or local authority is not a party to it, and make sure that maybe now you can bring the issue of writing. But I don't know, I'd be hesitant to bring the issue of writing because the controlled tenancy, the act says that a controlled tenancy is one that hasn't been reduced into writing. And if it's been reduced into writing, then the other conditions. So I'd mention those 3 conditions. Yes, Daniel?
Wait, Carol, I think you can see so many hands going up.
Yeah.
We've said that a controlled tenancy is not in writing, yeah? And it's for a period exceeding 5 years, yeah?
Our response was twofold. The Act defines a controlled tenancy as one which hasn't been reduced into writing. Or if it's been reduced into writing, it's for a period not existing 5 years. The only provision for termination is on breach of contract or specified by the Cabinet Secretary to be a controlled tenancy, and the tenancy where the government or the local authority is not a party.
And your answer was that we should just have, so long as we don't have it in writing, then it's out.
No, I was saying, no, I kind of contradicted myself. I said, perhaps I'd give the issue that it shouldn't be in writing, but then I said, perhaps that wouldn't be as wise, because now we've said that actually agreements not reduced into writing, tenancy agreements not reduced into writing, qualify to be controlled tenancy agreements. I don't know.
Yeah, I'm also thinking that maybe we look at it, if we look at it separately from the first question, then maybe it would be easier to answer it. Yeah, but if you put the two of, bundle them together, I think it could be a bit confusing.
Yeah.
Because I'm thinking we have to ensure that it's either it's not in writing, or we're saying that if it's in writing, then it's for a period not exceeding, so that it's outside, so that it's not controlled tenancy.
Yeah. Yeah, please.
So I don't know, maybe we can also get questions from there.
Yeah. And did you say it shouldn't exceed 5 years or it should exceed 5 years?
A tenancy agreement, a controlled tenancy is for a period not existing 5 years. So for it not to be a controlled tenancy, we'd have to make sure that the agreement exceeds 5 years, that the breach, the termination, there's provision for termination on more grounds other than breach of covenant. So everything that's opposite of a controlled tenancy, in short. Everything that's away from these requirements would help us break to make sure that.
So apart from that, Apart from that, the other difference should be the use of the property, since controlled tenancies for like shops, caterings.
Sure. There's that. It's actually apparent, but I didn't think of it. Yeah, there's the use because it applies to shops, hotels, and catering establishments. Yeah, sure. There's that. In this case, now we make sure it's for a parking lot. Very important. Thank you. Thank you so much. Yep, we can go on. Thank you. That's actually the third point, because I think you just make sure the term exists 5 years, that there are more grounds of termination other than breach, and you ensure maybe the government or the local authority is a party, whether as a landlord or a tenant. So since now we've said we're divorcing it from the first question, that would also agree, that would also be okay. And also now the issue of make sure that the premise is not a shop, a hotel, or a catering establishment. Very important. Rate clearance certificate. Yes, Odwar? Daniel?
Sorry, yeah. So I think maybe the issue that we are having is, if you look at the first part of the question, they're saying that they want the period to be for 1 year, yeah?
Yeah. But now,
yeah. So
these questions seem to be like they just wanted to test the issue of a controlled tenancy. So basically,
so if you if you separate them, yeah, but if you read them together,
yeah,
I think it's a bit of a conundrum.
Yeah, sure. Because now you have to make sure that now you have to start, of course, by knowing what are the requirements of a controlled tenancy, as we've said, as we've discussed. Now, everything that's the opposite of that will now safeguard our transaction. Cindy? So I think in that way we'd have answered the question right. I tried to look at the best performed paper, but unfortunately they didn't respond to this question. So I didn't quite get what the examiners were looking for. But I think that way we'd be safe, because we're even within the requirement, the act, the Landlord and Tenant Act. So I think we're right, because I think conveyancing is all about the law, the statutes. And if you can actually know the contents of the statute, there's no question that would bring you down. So have a list of those statutes. Make sure you interact with like at least 10 sections per day. Oh, the exams are now near. So make sure maybe you interact with more than that per day and do it again. Sorry, the procedures and the forms, and you'll be good to go. Yeah?
From the way I understood this question, apart from the first suggested 1 year, the other period should be more than 5 years.
Yeah, correct. So that it's not a controlled tenancy. We'd have to make sure that the tenancy period exceeds 5 years. And now your point that the premises is not a shop, hotel, or a catering establishment. And now the issue of termination. We'd have to make sure that the provision for termination has more grounds other than the breach of covenant contract. And we'd have the issue now of the government or the county government being a party, either as a landlord or tenant. So I think, yes, please ask the question.
I'm sorry, I'll have to take you back to question A. For clarity, were we looking at the differences of having a lease agreement vis-a-vis a lease vis-a-vis the differences of having, or the disadvantages and advantages of having a lease and a license? When you are explaining possible ways that you may consider in structuring the transaction.
Yeah, when we had to look at the advantages and disadvantages of each, so as to note the cons, the pitfalls. What disadvantages would the company's interests be? How would the interests of the company suffer if we chose a lease over a license? What setbacks would the company suffer if we chose a license over a lease? That's why it was important to look at both. So it's now
so to mean that the question itself was an open question, in that if you think that the company will not suffer based on them giving a license, you get all the 4 marks.
No, you have to identify. These are the cons that the company will suffer. If you have to identify the two, the lease. A lease is this, and this is the law. This is the Land Act. Under the Land Act, a lease is dash dash dash. A license is defined as a dash 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 dash. Now, in choosing the lease, sorry, can you please go down for a minute? Can you please go to the next page, page 3? Yeah, in choosing a lease of a license, the company would have certain challenges. You would be faced, the interest of the company would be affected in this, it would be adversely affected in this way. The issue of flexibility of the term, they'd have to give a notice, or the parties would have to agree for the term, for the 1-year term to be adjusted. Number 2 is the issue of the consideration. The consideration also would not be changed unless the party agreed to the agreed commission fee, unless the party agreed to, or, you know, a certain notice to increase the fee. So there's that flexibility that a lease lacks. No, the pitfalls of choosing a license would be the issue of perhaps now the company. We are looking at it from the company's point of view. The company's interests are what we are trying to protect, not Albert's. So from there, you'd look at the issue of, now you see now the flexibility that the lease lacks, perhaps the license could have, you know, and now that would be the advantages of a license. But now we're looking at the pitfalls that the company would suffer if they were to choose a license over a lease, since we've already gone over that over lease. And now you'd have to look at the issue of revocation, which is a plus, so it's not a pitfall. You'd also look at the issue of now, this is where now the issue comes in. You would have to consider whether the license is written or not. You see? Daniel, please, you said a lease can be unwritten. A lease doesn't have to be written or, yeah?
Periodic leases, I mean, we just read about periodic leases. They don't have to be in writing.
Periodic leases, yeah. Periodic leases. But I mean, in this case, I'd discuss the issue of lease. I'd discuss about leases, an agreement to lease, leases in the general sense. And this is how I'd approach the question. I'd look at it in the sense that, we've already looked at the pitfalls for a lease. Now, with regards to the pitfalls for a license, I'd say that the license wouldn't, because I'm trying to look at it in the way that you're saying and trying to be as clear as possible. Because all the conditions, all the information I see here is screaming a lease, from the way the parking lots should be maintained, the agreement on the commission, the defined premises. Yes, Daniel.
A lease has a defined consideration, yeah.
Mm-hmm.
When you talk about a license, yeah. So that's a disadvantage to the company.
It wouldn't offer them. Yeah, it wouldn't offer them. Yeah.
You could also talk about the fact that if you have a lease, then you have a defined premise, yeah.
Mm-hmm.
Yeah, maybe someone would say if you
a license, we're looking at the disadvantages of picking a license.
Yeah, if you give them a license, then maybe you're not able to confine them to a particular area. They could be able to access the land fully.
Yeah.
Yeah,
because even when you look at it, a license doesn't even give possession. It's just permission to use.
Yeah.
So I think also I'd assume, say, like, for instance, I'd give us, if it's not written, there'd be a problem with demarcating the boundaries of use. you're in line with that. Yeah, the boundary is
Because
obvious.
since a license doesn't need, defined
Yeah.
in any on the premise.
Yeah.
Unlike a lease that actually you have to define.
Yeah. So, but I think I believe the main thing is to know what are the ingredients of a lease and the rights, obligations of parties, the lessor, the lessee, and then also that of a licensee and a licensor. And it would be easier to twist out the question in any way that it will be tested. Thank you for that.
Yeah.
Rates clearance certificate. Aha. Albert requires that this be furnished to them before proceeding with the transaction. Advise your client on the importance of the statement, of this statement. The importance of the statement, it's that I think it's a condition, actually. It's a condition that Albert wants to be part of the transaction, to be fulfilled before they come to an agreement. And this is how do I call it? And I think it's part of Albert's due diligence. Basically, it's screaming due diligence, because the rate clearance certificate would actually be evidence that there are no dues that the company owes to the county government. While the rent is peppercorn, meaning it's no rent or there's a minimum amount that the county demands, it should show clean title of the property, and it's part of Albert's due diligence. Daniel, or anyone else, what do you think?
Let's have someone else try. What's the import of that particular statement? What do you guys think? And underline rates clearance certificate. So much has been said about it, especially when you talk about completion documents and the rest. Yeah. What do you guys think about that statement? Anyone, guys? Today I think we've had so many answers being given to us. So let's try. Anyone? What do you guys think about it? He requires that a rates clearance certificate be issued to him before he can proceed. What do you guys think? Yes, George?
Okay. I think for me, it is part of due diligence, and due diligence is to make sure that you remove any doubt or if there is any encumbrance to the suit property. So it is the issue of encumbrances.
Encumbrance? Okay. This is not an encumbrance. Okay, George, please.
Guys, time is not on our side. Or can we say that maybe they'll look at it, Caroline, so that you're able to move to question 3? Maybe we can have an answer discussed in the group. Yes, Caroline, maybe we move to question 3. We can also talk about it when I'm done. We can just go back to it.
What if we say compliance with legal regulations because of the provisions of Section 38 of LRA?
That provides that.
It provides that prior to the registrar accepting any document intended to transfer land for registration, there must also be produced a valid certificate or statement showing that the rates has been cleared or paid up. That's from my notes, although I don't have the act here. Someone can confirm. the exact provision.
All right, we hear you. We hear you. Okay. Henry, thanks for that answer. Henry?
Let me try. Yeah. I'm thinking that the fact that there is a development to be done, that is a parking. Definitely, the tenant will require to get approval from the county, and he'll not be able to get approval from the county without rest being cleared with the county. So it requires the rest clearance certificate.
At this point, sorry, Daniel, please let me highlight this and we can go on. At this point is at the point where the transaction hasn't even started. He's considering on proceeding with the transaction. So at this point, he's gathering all the information he can about the property. In conveyancing, the first question you ask yourself, is it a pre-contract, contract, or the other part of the transaction, phase of the contract, of the transaction phase? What phase are you dealing with? In that case, you're able to know what response is appropriate. I can see a hand up, and I can't quite know who it is. Please.
Yeah, I just wanted to say that if you don't have a rate clearance certificate, forget about registration by the registrar. So I think it should be good even for Albert to have that in mind, because at the point of registration, it may not be possible to register without the rate clearance certificate.
Okay, Sasawa, thank you. Yeah, Barak? Barak, please.
I'm the one who has spoken,
Oh,
Caroline.
Okay, your hand was still up. It's okay. George, please.
Just to enumerate on what I said earlier about the encumbrance. You know, if this person proceeds with the transaction without having the documents, the clearance certificate, then it means that all the liabilities will be borne by him. So he should avoid the issues of encumbrances at this stage.
Yeah, that's correct. Okay, please, can you quickly go on to number 3? Since I hope you've all gone through the questions. It's on the procedure of the first part. A is on the procedure of obtaining a lost title. A title after you've lost the original one. So it's replacing a lost title. I'll quickly go through it. Please, we need to give Daniel enough time to go through his questions, which are also comprehensive. This is covered under Regulation 27 of Legal Notice 278 and Section 33 of the LRF, which states that where a certificate of title or certificate of lease is lost or destroyed, the proprietor may apply to the registrar to issue a duplicate certificate of title or lease. The registrar shall require a statutory declaration to be made by all registered proprietors, or attach a police abstract and identification documents of the proprietors. If the registrar is satisfied with the evidence proving the destruction or loss, and after the publication of such a notice in the Gazette for 30 days, and in any 2 local newspapers of nationwide circulation, it's 60 days to allow for lodging of objections. The registrar may issue a duplicate certificate of title upon expiry of the 60 days from the date of publication in the Gazette. If the lost title is found, it shall be delivered to the registrar for cancellation. The process is as simple as that. That's it. It's as simple as that. Please check Section 33 of LRA and Regulation 27 of the Legal Notice 278. You have received instructions from Kenya Commercial Bank to recover an unperforming loan by selling land used as security for the loan via an action. Please. what are the considerations? What are the considerations you'll take into account in instructing to carry out this work? Number one is a comment I made in the first question. Make sure they're licensed, they're registered under the Act. Number two is the jurisdiction. You see, please go back, go up. And of course, this is please go, the person projecting the paper. I need to see the top paragraph in its entirety. Yeah. Also, the premises, the registered premises of the auctioneer. We are told that 5 acres of parcels of land owned by the cane farmers that you'd want to use to set up the hospital. So it's the parcel is located in Butere. So we'd have to make sure that we know the registered auctioneer is somewhere around there, because we can't have an auctioneer in Nairobi, registered premises in Nairobi, but we want him to enlist him for an auction that could possibly happen in Butere. So I think these are the two considerations I'd make. Someone else, please. George. George, please, mainly because of time.
Sorry, that was the old and.
Yeah.
That was the old and. I'm still looking at the question.
I can't quite hear. Oh, sorry, Daniel or anyone else with a response, so that we quickly finish these, because Daniel has a lot also that he needs to cover. Those are the two considerations we'd have to make in instructing an auctioneer, because it's we can't start discussing the issue of advertisements of the auction and everything, because at this point we're instructing the auctioneer. So we have to make sure they are qualified, and we have to check out their registered premises. Daniel or anyone else with any other response, please.
Yes, Caroline, I think
Yeah.
I think you have sufficiently covered it. Maybe what I would add is they must have taken out a practicing certificate for that.
Yeah, we've talked about licensation.
Yes.
They have to be licensed and perhaps registered with whatever registration requirements are required in the Auctioneers Act and the attendant regulations. Perhaps, yeah, you can go further and research further according to the Act. What else? What else is required for auctioneers?
There's always a provision that talks about whether they'll require policemen. I don't know if you remember. And if they'll require help from policemen, there's an application that you need to make, and you need to get an order from the court allowing them to go with policemen, so that it's not seen as
at the point that we're instructing them. At the point we're giving them instructions. Oh, that's okay.
Yes, whether, in your opinion, whether, in conducting the duties that they're conducting, I mean, it's always good to start early. Would they require, depending on, the temperatures down there?
Yeah. Sure. That's okay. Thank you. We have our 3 responses. We can go to the other part of the question. Please. Okay. Advice on the steps your client and the auctioneer are by law required to take to ensure that the intended process is regular and lawful. Please, someone please quickly. This is under the Land Act, Someone please. Or please.
I can try.
Yeah.
So can I start with section 90?
Yeah, that's exactly
rectification. Rectification notice. You need to give a rectification notice to the client. If it is on an obligation, it should be 2 months notice. If it is on failure to pay, it should be a 3-month notice. So if they fail to do that, then section 96, notice of intention to sell, it should be 45 days. Yeah, then I think if they don't act on what you notify them to act on, then now you instruct. I'm just giving a top line.
Yeah, please proceed.
Yeah, so you instruct an auctioneer who will issue a redemption notice, which should be, I'm forgetting the number of days, between 40 and 45 days. Then if they don't redeem, then the auctioneer will advertise and auction the property within 14 days after advertisement.
Could you mention something about the value, the for sale value and something of that sort?
Yes, of course, there has to be a reserve value. You have to do valuation and get a reserve value with which at the auction, the bid must be above the reserve value. I was just giving the outline.
That's actually it.
That's actually it.
That's actually it. Please, because of time, look at the Land Act from Section 90 and look at the auctioneer rules and make sure you have the process at your fingertips, just in case it's retested. Thank you so much for your time. And again, I can still say it. Please make sure the provisions of the acts, the procedures, the legal notices, especially legal notice 278, both the regulations, and at least you have an idea of how the form looks like. Please have an idea of everything. Now, we were tested on the agreement for sale. You can be asked to give a completion notice, or something of the sort. Just look at the transactions in their entirety, because anything can be tested in conveyancing as long as it's in the laws or even the emerging issues. Thank you so much for your time.
All right, guys, let's just clap for Caroline for such a good work. I mean, that was quite enjoyable. Thank you so much, Caroline. Yeah, thank you so much for that first part of the session. I hope you guys have learned. Caroline, you're free. You're free to stay with us. You're free to engage in other business. But we'll catch up later. We'll talk. Guys, now let's move forward, and now we have to change the environment a bit. Let's be active as we are, as always. Let's try our best to be active, because now we are going to answer the questions together. Again, I just wanted to correct something that you said, and thank you so much, Pius. I think that was quite clear. So we have 90 days, guys. We've talked about this so many times, guys. And this question always, I don't know, it was there in our paper. It is in this paper. I've seen this question in so many papers. Sale by public auction. First step is 90 days statutory notice. Then we have 40 days notice of intention to sell. Then we have 45 days redemption notice. Then we can do land valuation, so that when we have an advertisement by these, auctioneers and whatever, we already know how much we're selling this land at. And if you look at the case of David Gitomi versus Equity Bank, the valuation must be as latest as yesterday. So valuation is very, very important here. We must have valuation. Then advertisement for 14 days, as you said clearly, Pius, which is very correct. Then we will have the sale to the highest bidder. Okay, then you can go ahead and talk about the certificate of sale, memorandum, and everything else, and registration. But I think if you reach there, since we have 3 marks, that should be okay. So, guys, at least public sale, public auction, that should not be a problem, guys. It should not be a problem. At least that one should not be a problem. Attorney 001, you have a question or something before I move forward?
Yes, I want to ask a question. Is it mandatory, or is it a must that the sale must take place after evaluation has been done, or it can take place in the absence of an evaluation?
Now, it is compulsory. It is a must. you must have done valuation. I mean, before you go through sale by public auction, you need to have a reserve price. How are you going to have a reserve price if you don't do valuation? Now, again, I'd like to bring your attention to the case of David Gitome versus Equity Bank. Exactly what you're talking about in your second question. That's what happened. Equity Bank decided to do sale by public auction, but they had not done valuation. That sale was actually annulled. They had to redo it. They had to do it again. They had to do valuation before they do everything else. So it is mandatory. If you look at the case of David Gitome versus Security Bank, it is mandatory that you must have done valuation before you sell someone's property. Now, why is this very important? Imagine I gave you a loan in 2014 and your land was valued at 20 million. Now I'm recovering my money in 2025. And I'm still saying that your land is valued at 14 million. I mean, land appreciates. Land appreciates. I cannot say that your land still has the same value as it was in 2014. And that's why it's very important that when I'm selling your land, I have to be fair. I have to use the value that your land is valued at this point today, because land appreciates. That's why it's very important, and it is a must. It is compulsory that you do valuation before you do sale by public auction, so that we have the reason value. Okay.
Okay.
Does that answer your question?
Okay. Yes. It has answered. It has answered me. However, I'd like to just ask a follow-up question on the same. What if the valuation is an undervaluation?
The valuation is what?
It is the property is undervalued, so that the property is undervalued for it to be able to get a buyer instantly, so that the person who is the person who owes the bank suffers some form of prejudice. Can that what recourse does that person has in court if the property is undervalued?
Now the person must contest that particular sale at public auction, and of course the evidence they'll be bringing to court is the fact that yes, the land was valued, but it was undervalued. Now they'd have to prove attorney 001, they'd have to prove that truly the valuation was not the right valuation. If they're able to prove that, then I'm sure the sale will be annulled and a new valuation will have to be undertaken. If they can prove, only if, but valuation must be done either way.
Okay.
Yeah, you can just
answer. I think it's okay then. I'll just allow
All
others
right.
to ask questions.
All right, or you can ask just yes, go ahead. There's another question from Barack. Barack, go ahead.
No, I just want to add to your voice that the person will have to prove that, and in most cases, it's not just one valuation that you can go with. You can actually do an independent valuation. If you can't do then, as part of the remedy or the orders the court might give, if you went to court, then the court might order an independent valuation, as was done in the case of Levy House construction. And there's an engineering limited against ABC Bank. So the court might order an independent valuation. So the way to do away with that mischief of undervaluation is to do independent or many valuations, so that you don't rely on just one valuation.
Yeah. Then of course you also have to ensure that the value you're using is a license to value and not just any valuer in the market. Thank you so much. Okay, I believe that is done. There's no other question, guys. We should not fail any question on sale by public auction. From all the questions, at least that one we must die with. Question on public valuation, we've talked. Public sale by public auction, we've talked about it here again and again and again and again. Okay, so at least that one. Yeah.
Kindly just repeat. I was writing it down.
Sawa. Let me repeat quickly again, just to remind other people. It's a question that it's almost in all. I've seen it in so many papers. The process: 90 days statutory notice. That's the first step. 40 days notice of intention to sell. 45 days redemption notice, land valuation by a licensed valuer. You can couple it with the case of David Gitome versus Equity Bank and the one that Barak just talked about in instances where we have undervaluation. Then you have advertisement of sale by auction, which is usually 14 days. Then finally, you have sale of the property to the highest bidder. One thing that I think, Pius, you talked about is reserve price. It's quite important. If we are selling this property, we have to start from reserve price going up. We can't sell it at a price lower than the reserve price. Now, for us to know the reserve price, we must have done valuation. Again, these are just things that are put in place, remedies that are put in place to ensure that the person whose land we are selling is not, trouble in any way whatsoever. Their rights are still protected, even as we proceed with this particular sale. Because again, you'll realize that if you don't do that, there are people who will just be selling people's land to other people cheaply by colluding and making other people richer as other people lose their property. So it's quite important that we go through this process, and it's quite important that we protect both parties. Okay. I want to believe that now I'm free, I'm not encumbered, and we can move forward to the next question, which is question 4. I'll read it out loud. I want us to do this quite quickly. The Kim family has lived in Bora Estate in Nairobi for the past 6 years, having bought the house through partly family cash, savings, and partly by way of a loan from Baraka Housing Finance. Mr. Kim, while speaking to a colleague at workplace, learned that titles within most parts of Nairobi, including Bora Estate, are required to be converted to a new form of title. You keep moving the cursor and it's a problem. New form of title. And that the process is time-bound. The Kim family has approached you asking to understand the nature of this requirement and what they should do to comply with the same. Now, I talked about this during our orals, and I remember the people were wondering, do you mean converting public land to private land? Do you mean converting private land to public land? It's conversion, yes, but it's a different type of conversion. It's not that type of conversion that we've had or that we've known of for all these years. It's a different type of conversion. It's the one done through Ardhisasa. Okay? This is where we are moving titles from the old regime, the old LR numbers, to one that is uniform and unified, so that the properties in Nairobi will be Nairobi block this. In Kisumu, we'll have Kisumu block this, so that we have some unity, so that we have some uniformity in titles. You just look at a title like this and you know where the title is. So that, right now we have, you look at a title and it's written IR this, IR that, grant this, grant that, grant what, LR this, LR that. And sometimes it's very hard even for you to know where is this title from. There's no uniformity. Everything is just everywhere. It's all just madness. So we are the Ministry of Lands and the Land Registry are coming up with a system to ensure that we have uniformity in, the title numbers, the numbers for the titles that we have. And to ensure that we have that uniformity, all the titles, for example, now they've started with Nairobi. The titles in Nairobi are taken back to the Lands Registry and you're issued with a new title number, which is more uniform, that is easily identifiable. Okay? So it's different. It's different from the conversion that you guys have known about. And I think we talked about this thing and we talked about the process. And I told you it's an emerging issue. How will you establish whether the Kim's family title requires conversion? And what is the basis of conversion? Anyone who'd like to try? How will you establish this? Anyone who'd like to try? How would you establish if a title requires conversion? Anyone? And I think I've defined the type of conversion that I'm talking about. And I gave you guys the formula. I gave you guys the procedure. I explained what it means. How do you identify that a title requires conversion? Anyone? Guys, anyone? Today we are slow. I wonder why we are slow today. If your hand is raised, go ahead. Okay, so I want to believe no hand is raised. So if you're writing, let's take notes. I think this is something that probably we are not. Yeah?
Daniel, there's a hand here from George Otieno.
Go ahead, George. I think it's an old hand, Bernard, so I'll just go ahead. Please, let's take notes. Let's deal with this thing for the last time. What's the meaning of conversion? It's conversion or migration of land registers or registers, yeah. So conversion, if you're writing, is a statutory process that refers to the process of changing the title numbers issued under the various repealed land registration statutes to a new uniform unitary regime following the creation of new land registration units as provided under Section 6 of the Land Registration Act. So it's basically a statutory process that refers to the process of changing the old title numbers to new title numbers, which are unitary and uniform. Now, what are the importance of us going through conversion? Why are we introducing this animal, for lack of a better word? One, it speeds up service delivery in the land departments through consistent indexing and documentation of land data. We'll have uniformity, we'll have consistent indexing, it will be easy to identify titles. So it speeds up service delivery in the land department through consistent indexing and documentation of land data. Two, it addresses the threat to the right to property. Why? It gives us more control, especially when it comes to where you are buying land. You're able to know that this one is in Nairobi, this one is here, this one. Someone doesn't give you a title that, a title for property in Nairobi, in Migori County, yet the land that they've shown you, or the land that you went to see, is in Kilimani. So you end up with a title for Migori County, yet the land that you want to buy and what you saw was in Kilimani. Three, it helps curb fraud, including cases of stolen land. Why? Because only registry index marks shall be used for registration of titles under the Land Registration Act. So certain registry index marks will be used and not, as we've been doing before. Four, it will do away with inaccuracies such as double registration and mismatching of land ownership, since the details are uniform and easily identifiable. You don't have to write everything. Five, it will help harmonize land valuation, since sometimes you'll realize that someone is valuing for you a land in Kisumu, and if you look at the value, it looks like a land that is somewhere else. So at least it would be possible to know these values depending on location, since these locations will be shown in whatever you have in the title. Yeah, of course, it will also help speed up land transaction through improved land administrations and easy identification of documents. Now, I'll go to the second thing. What is the procedure? What is the procedure for conversion? I want to believe that we are still together. What is the procedure for conversion? This is the procedure. The first step is gazettement of the property in the Kenya Gazette for conversion. Gazettement of the property in the Kenya Gazette for conversion. So the Kenya Gazette, the Ministry of Land always issues gazette notices for conversion for properties that are supposed to be converted. So there are gazettes all over for properties that are supposed to be converted by now. Those gazette notices are out there, and you can check and know whether your land or your dad's land or your sister's land is supposed to be converted. And we talked about the process of conversion. Two, creation of Ardhisasa accounts. Ardhisasa accounts are supposed to be created by the owner of the property. And of course, advocates also have Ardhisasa accounts. And I think even most of us, we have Ardhisasa accounts, yeah? So fractional of adversarial accounts, we have your advocate, because if you go through the adversarial system, it's only advocates who are able to make this application for now. Now, there are stories that this application will be open to the general public and everyone else can be able to make this application. Again, that is a story for another day. So your advocate will make an application for conversion through the adversarial platform. Your advocate will make an application for conversion through the adversarial platform. Before they do that, you should also have your account, even as your advocate makes the application. 3, the owner of the property, the proprietor, will consent to the conversion by affirming an electronic signature. So even though your advocate has made an application, you have to consent to that conversion by inputting or affirming your electronic signature. 5, uploading of the title document on the Ardhisasa platform. The title document, the one that you have, this old one, the one from the repealed regimes, it will be uploaded into the Ardhisasa platform. So uploading of the title document on the Ardhisasa platform. Then we have verification of the uploaded title by the land registry. So after you've uploaded the title, the verification will be done by the land registry. Imagine a situation where this verification is not done. Someone can just upload a title and just do whatever, and they'll move forward and they'll get a new title. Probably you don't even know that someone is doing this. So that's why preventive measures have been put. Before the conversion is done, you must append your signature. You must consent to that particular conversion. After that, they have to upload your title. They cannot just upload any title, then they'll end up getting a new title. They have to upload that particular title. Then the land registry must verify that the title that has been uploaded and to whose consent you have given, is it the right title? Is it the title that is supposed to be converted? They have to verify with the deed file, as we've been told by Caroline, that they also have their own deed file. The mirror principle, they're also able to see, does it agree with what they have? Does it agree with what they have there, this title that they have uploaded? If it does agree, then you'll get a response from the land registry requesting you to surrender the hard copy of the title. So that's the next step. After verification is surrender of the hard copy of the title to the land registry for issuance of a new title. Then lastly, issuance of a new or converted title by the lands registry. Guys, I think that was very clear. This is an emerging issue. This is something that we have to know about. This is very important. In fact, because of conversion, right now, even banks are not able to do charges on properties unless those properties have been converted. You can't discharge your property unless your property has been converted. You cannot transfer your property unless your property has been converted. And that is and only if that particular property has been gazetted for conversion. So how do you know that you're supposed to convert your property? If it has been gazetted for conversion. And so that answers our first question. How will you establish whether the Kim's family title requires conversion? If and only if it has been gazetted by the Ministry of Lands in the Kenya Gazette for conversion. What is the basis of conversion? Now, anyone would like to answer this question? Why are we doing conversion? Anyone? I've answered this question multiple times. What is the basis for conversion? To ensure what? Anyone? Anyone, guys?
I think it's to ensure that the existing titles are conversant or in line with the existing laws.
Mm-hmm.
Because you will only convert a title if the regime under which the title was registered was repealed. So you will have to bring that title into the current regime, which is conversant with the current law.
Yeah. And I just to add more to what you've said, it's also to ensure a unitary regime, to ensure uniformity in title documents. Yeah.
And Daniel.
And
Yeah.
also prevent fraud.
Prevent proud. Yeah, I think I've given you. I've given you so many grounds for this conversion. But I think one thing that's more important is what George has talked about, to ensure that this old and repealed title are conversant with the new laws, and to ensure uniformity in land titles regime. Uniformity and what we've talked about. B. So please, at least when you're answering this question, ensure that at least you've talked about that uniformity and bringing them, I would, for lack of a better word, up to speed with the laws. B. Discuss the process of conversion of titles. Yeah, go ahead.
So maybe where we can refer the information that you just told us, and then there is also another conversion. If you look at Rule 19 of the Sectional Property Subsidiary Legislation, there is also this other conversion. I don't know whether you can also talk about it, because it's also a bit confusing. Because in my head,
what are they talking about?
They're talking about an application for conversion under Regulation 18. So conversion to sectional units. You remember before there was this sectional property were being given under subleases. Huh?
Yeah, and so we had subdivisions and all that.
Yes, so they are supposed to be converted to sectional units.
Yeah, that's
yes. So if you look at Regulation 19 and 18 talks about conversion. So
all right.
It was a bit confusing.
That's in relation to sectional units and subleases. Now,
yes,
I'd say that there's a connection because both of them are in relation to, but you see, what I'm talking about right now is in relation to the Land Act. The conversion that you're talking about, right? The conversion that you've talked about is in relation to the Sectional Properties Act. Okay, so it's the Sectional Properties Act that talks about conversion of long subleases or whatever to the sectional units. Okay, so that's a different type of conversion for sectional units. The one I've talked about just right now is in relation to the normal titles that we've had all over this while. They are being converted to the new regime. So it's a bit different from what we've talked about. But I of course, that one is also present.
Any place where we can refer?
Okay, now you can talk to any advocate out there, because they can, or you can look for articles. It's not written specifically in laws. I've not seen it exactly, but that is the process. Now, if you want to confirm, again, they say trust but verify. I mean, you can go to a law firm, you can call any of your buddies who's a lawyer, ask them if they've done conversion. They can confirm the steps that I've given you, or they can, probably they have a different form. But please, if anything is different, just you can ask me, you can confirm with him, oh, Daniel, this guy is saying this, what do you think about this? And we can always iron these issues out. Is that okay, Pius?
Yes, thank you.
I've not found it anywhere, but yes, this is the process as I know it, because we've done it for quite a number of titles. Yes, Bara? Old hand?
Okay, I'll share something with Pius on this. There's a manual that was given, but otherwise my question is, now if you met a title that is under the old regime,
yes,
with reference to question A, isn't that a way to know that it needs conversion, or that's not sufficient?
Not
you
sufficient.
met a title that is under GLA, or is it registered?
Not sufficient. You see,
it's not,
titles are only converted if they've been gazetted for conversion.
Okay.
Yeah. So gazette notices are given, and it's only after you have a gazette notice. That's, in fact, even for us where I work, we don't issue titles for conversion unless you can give us gazette notice showing that here is the gazette notice. It was published on this day. It says that my property LR this is supposed to be converted. Without that, nothing moves.
Okay.
Yeah.
Then a follow-up question.
Yeah.
Now, okay, assuming you have a title that is under the old regime,
Yeah.
So when you're doing this transaction, maybe you want to charge it or something of the sort.
Yeah.
Will it come out in new numbers or in the new title, or it will come back the same? What will
You'll
happen?
have the same title. You'll have the same title, just that something will be added to the encumbrance section, the way they've been doing ever since.
Oh, so it's not
Like
automatic that it will come converted?
No, if you're doing a charge, it won't come converted. You'll take the title that you have to the land registry. The land registry will record this new charge that you've done on your property, so long as your property has not been gazetted for conversion. If your property has been gazetted for conversion, first you have to convert it. That is when you'll be able to do a charge or a sale or a discharge. So if it has not been gazetted for conversion, you can still do the way you've been doing ever since. Go to the lands registry, give them your title. They'll record in the encumbrance station that now you have a 5th further charge, that now you have a 6th further charge, you have an 8th further charge, whatever. But now when they gazette it for conversion, you take it as is to the land registry. They'll give you a new title that has all these charges in the encumbrance section. After that, of course, you can do this simultaneously. It depends on who you know and where. After you have this new title, then now you do this new charge on this new title. So I'm not saying that if you have a new title and you do a charge, you take the title to the land registry, and when the title comes back with a new charge, it comes back converted. Those two must be done separately. Does that answer your question, Barack?
Well, that's illuminating. So I'm just confirming that if it appears in the gazettement that it ought to be converted and you have not done so, so you stop everything, you convert first, so you cannot do those two things together.
Well, I've said depends on who you know where.
No, I'm not talking about the straight and narrow path.
You need to first convert it, because what the law says now is that you cannot do anything with that title unless and until you convert it. So once you convert it, that's when the new title is out, they'll now register the new charge on the new title.
That's clear. Thank you.
Yeah, but of course you can always say do this. Even as you surrender the title for conversion, you've already drawn the charge. The parties have signed. Everything's in place. You're just waiting for that title to come out and straight. You just pick it from the lands registry and return it back with the charge, and they'll do whatever they're supposed to do. You get? Barack, that's okay.
I get it. Thank you.
All right, George, quickly.
Okay, my question is,
yeah,
you have just begun with the gazettement.
Yeah.
Can someone just wake up and do a gazettement to your land, or you make application for it to appear in the Kenya Gazette or in the Gazette notice?
I have not seen people making applications. I don't know if someone can make an application and that happens, but from what I have dealt with, from my experience, the gazettements are being done by the Ministry of Land discretionally, for lack of a better word. They're the ones who are deciding, and they're the ones who are gazetting this particular property. The properties that they have not gazetted, there's some which they have gazetted. Now, the gazette numbers are also different, but from what I know, they're the ones who are gazetting. I don't know if people can make applications, but I know they are gazetting as they wish. And they've decided to start with Nairobi. In fact, the people do not even know that their titles have been gazetted. So I don't think really you have to make an application. The guys who do not know, you talk to them, you call them, and they have no idea. But the gazette notice is there.
Okay, thank you. For if it is discretionary.
Yeah, they're the ones who do it. Now, whether you can make an application and they'll still do it for you, I have no idea. Again, probably, maybe it depends on who you know where. I'm not telling you guys to be like someone else. Anyway, let's continue. So we've answered question A, question B. We've talked about the process. So the title to Kim family home is encumbered by a charge in favor of Baraka Housing Finance. How will you convince Baraka Housing Finance to release the original title for purposes of conversion? I've answered this question. Anyone who would like to answer it when I was talking about charges and everything else? And I think someone has also put the answer there. So what I said is this. The title which is now being held by Baraka, which is a housing finance, that title, once it's been given to you, you'll surrender it to the land registry. The land registry will give you a new title. Now, the good thing or the beauty behind this is this: that new title will come out with all the charges in the encumbrance section. They don't have to be registered again. This new title that you're going to get, the converted title, it will come back with all the charges. So Baraka Housing Finance has nothing to worry about. But of course, I can't just give you my title and tell you, oh, yeah, oh, that's what's happening. Oh, I didn't know. Oh, take the title and go. You must give a professional undertaking. So you must have an advocate who is able to give a professional undertaking to an advocate of the bank. Then the advocate of the bank will request for the title from the bank. The bank will give the title to the advocate of the bank. The advocate of the bank will give the title to your advocate based on that undertaking. Your advocate will undertake conversion, bring the title back to the bank's advocate, and the bank's advocate will send the title to the bank. Any question?
Hapo umeenda haraka, rudia kidogo tu please.
Sawa. So what the beauty here is, we have something called professional undertakings. Now, the bank cannot just give you even though you will tell the bank that, oh, you know what, even though you've given me this title, when I take it to the land registry for surrender, it will come back with all your charges in the encumbrance section. So you have nothing to worry about. They cannot just give you the title based on that. So then you have to give a professional undertaking. There must be an undertaking allowing them to give you the title. This question that we have is asking, the title to Kim family is encumbered by a charge in favor of Baraka. How will you convince the bank to release the original title for purposes of conversion? This is what you can do through your advocate. First of all, what you can do is inform the bank or explain to the bank that when the title is issued for conversion, the new title that will be the converted title will come back with all the charges that have been registered by Baraka Housing Finance in the encumbrance section. However, for them to release to you the title, your advocate will give a professional undertaking to the advocate of the bank. What will they be saying? That once you give me the title, I'll only utilize it for the purposes of conversion, nothing else. I'll hold it to your order. If the conversion process takes more than this time, then you can ask me and request me for it, and I'll return it back to you, and things like that, left, right, and center, ensuring that you cover everything. So once your advocate gives the professional undertaking to the advocate of the bank will request the bank for the title based on their agreement. Then the advocate of the bank will give your advocate the title. Your advocate will go and do conversion and everything else. Then once conversion is done, the new title is out, your advocate will send the converted title back to the bank's advocate. Then the bank's advocate will send the title back to the bank. Is that clear, or I'm still fast?
It is clear, it is clear.
Thank you, George. Moving forward. Question 5. Anyone wants to read for us? Donna, are you in?
Yes, I'm in.
I can read.
Okay, you'll read question 6, Bernard. Donna, read 5.
Okay, so 5A, Ocean View Limited has developed a block of 40 flats on their parcel of land known as Kilifi/Kikambala/330, located in Kilifi County. The flats have a beautiful view of the Indian Ocean, and the company is proposing to sell off some of its interest in the property. The directors of the company have approached you for advice on which model between fractional ownership and sectional ownership would be appropriate. Discuss why you would prefer one model over the other. For marks.
Okay. Absalom, please move up a bit. We can't see the question. Just scroll up a bit. As you do that, please, anyone, what's the difference between the two? Sectional and fractional. Anyone? Let's deal with this fast. What's the difference between the two? Absalom, please move up. Move. Move to question 5, Absalom. What's the difference between sectional properties and fractional titles? Anyone, guys? Anyone? What's the difference? If your hand is raised, go ahead. What's the difference between the two? Guys, what's the difference between the two? What's a fractionary title? What's a fractional title?
Let me try, Daniel.
Go ahead.
So a fractional title is a title where there are more than 2 people who own the property in, can I say proportions or fractions? So each person is registered owner until they sell their fraction. While sectional property is where one has exclusive ownership of a property. Under Sectional Property Act.
Okay. That's nice. Great. Good trial. At least we're on the right path. Anyone else would like to try? Guys, today you're cold. I don't know what's up. Today people are quiet. Sawa. Let's still, even if that is the case, if you live here with us, we have to try. And the ladies today, no one is speaking. Anyone? Okay, what's a fractional ownership or a fractional title? A fractional title refers to the ownership of a percentage of actual brick and mortar. However, this type of ownership entitles a person to use the property for a certain time and under this system, you can transfer your ownership to someone else. So here you have ownership of the way Pius have said, you have ownership of a property, but you have the right to use the property for a certain time. So we can say you'll use the property in December and January. I'll use it in February and March. Use it in April and May. I'll use it in June and July. Use it in August and September. I'll use it in October and November. Again, use it from December and January. So you own the property, but you can only use that property for a certain period of time. You own it, but you can only use it for a certain period of time, and you share it with someone else. January to February, it's Pius who can go there, do whatever they want, have parties, have events, do whatever they want. And again, I think this property is in Kilifi or something. Okay? But what do we mean when we talk about sectional? If you have a sectional title, then you have total ownership of that particular property. There's nothing of, someone will own it in January and February. You have full ownership to own it every single time, all through the year, until you sell it to someone else. That is the difference that we have here. In fractional, you own the property, but you can only use it within limited period. And once your period is done, you can't use the property. Yes, you own it, and you can transfer that right. But under sectional title or sectional properties system, you own the property fully. You own it fully. Just that under sectional properties, we have mansionettes or we have flats, and someone fully owns the first floor, for example, someone fully owns the second floor, someone fully owns the third floor, someone fully owns the fourth floor, someone fully owns the fifth floor. That's why it's sectional. It's one big building, but it is owned sectionally. However, it is owned fully. You own that section fully. But under fractional titles, yes, you own that particular property, but you can only use it within a limited period. You can't use it every time, unlike if you have a sectional title. So they're saying that, what's the question? The directors of the company have approached you for advice on which model between fractional ownership and sectional ownership would be appropriate. Discuss why you'd prefer one model over the other. Anyone? It's the property is Ocean View Limited has developed a block of 40 flats on their parcel of land known as Kilifi Kikambala 330, located in Kilifi County. The flats have a beautiful view of the Indian Ocean, and the company is proposing to sell off some of its interest in the property. Okay, so the director of the company have approached you. What did you tell them? They want to sell off. These people want to sell off. It has a beautiful view of the Indian Ocean, and they are proposing to sell off some of their interest in the property. Which one would you tell them to go with, and why? Anyone? Anyone? Would you tell them to do fractional? Would you tell them to do sectional? Anyone and why? I've defined the two, and I think now it's quite clear the advantages and the disadvantages. If they decide to go with fractional, yes, they'll still own these properties, but they'll have the right to use them only within certain time. They can't use it all the time. If they go with sectional, there are some that they'll use fully, but there are some they'll have to give out fully. Anyone? You can choose any and give your reasons. Why? Yes, Donna?
Okay, in my opinion, I think I'd go for sectional ownership because they want to sell off their interest, and under sectional ownership, it confers exclusive possession to the people who will be buying it. Whereas I think in fractional, they still have some rights and interest over that land. So I'd go with sectional ownership.
So you're saying in sectional they're able to sell off, but in fractional they're not able to sell off?
No, they want to sell off some of their interest. So when they sell it under sectional, under sectional title, the people who are buying will get the land fully, and can only revert back to the company when now maybe the period of the lease imeisha. Whereas in fractional, they'll still have an interest, for example, maintaining the property or something, I think.
Yeah, and they'll have to share it with these guys. These guys can come in January and do whatever, probably make changes, or they're not good people. They damage the place here and there when they're using the property, and they'll still have to maintain them since they own the property fully. All right, George.
And I have a question. Sorry. What is the difference between? Pardon?
Yeah, go ahead.
What's the difference between fractional, whatever, and timeshare? Are they the same, or is there a difference?
No, there's a difference. In timeshare, you have the right to use the property within and during a particular time, but you don't have, or you don't own a tangible asset. You own the property, you own the right to use, but you cannot sell that right. You will have that right forever. You can't sell it. You can't dispose it. The reason why sometimes people go with the timeshare is because they don't want someone to just bring in. Remember, you are sharing the house. I only want to share that house with Pius. I don't want to share it with anyone else because I don't know how responsible they are. To ensure that Pius cannot sell and I cannot sell the right to share, we go with timeshare. At least I know Pius. At least I know Pius will not, cannot do this and that. I know Pius is responsible. So I only want to share with Pius. And so me and Pius will own that property forever. But in fractional, I could own it today with Pius. If I'm tired, I can sell it to Donna. If Donna is tired, Donna can sell it to George. If George is tired, George can. And so different people can come in at different time. But in timeshare, that cannot happen. We all have to stay with Pius probably forever. I hope that's clear. Yes, George?
Yes.
Okay, George?
Okay, for me, I'll go with I'll advise them to go with the sectional property, because once in a sectional property, once you have registered it, then the mother title is always closed. Then there's establishment of corporation company, which is responsible management company corporation, which will be liable in case of any breach, not the directors.
So you're going with that because of the fact that the company would be liable for the breaches and not yourself.
Yes.
Okay. Anyone else? I've not found anyone who'd like to go with fractional ownership. Anyone would like to go with fractional and their reason? Okay, I've defined the difference between the two. I think maybe during your free time, you can just look at those and see if you're able to at least try and have 4 or 3 reasons as to why you'd go with one and not the other. B, Igla dreams of owning her own home. She recently took her first loan and is actively scouting for properties around Kitengela and Kajiado County. During her recent visit, she met up with Peter, who introduced himself as a land broker in that particular area. Peter drove her around as they viewed several properties, and she identified a particular one for her purchase. Igla has approached you for legal advice on the transaction to protect her interest. You have conducted an official search on the property and learned that the registered owner of the property is deceased and the property is encumbered. Explain what your advice would be to her in this circumstance. Anyone? The owner is deceased, the property is encumbered. What would be your advice to Egla or Igla, depending on where you drank your first water? Anyone? What would be your advice? Yes, Magdalene Wangui.
Yeah, I would first request the
Yeah, we can't hear you, Magdalene. I don't know why. What would be your advice to Egla? You'd advise her to? We can't hear you totally, Wangui. Totally. Anyone else? As Wangui sorts out the issue. Anyone else? What would be your advice in this circumstance? Guys, is it time or what would be advice to her? The owner of the property is deceased and the property is encumbered. What would be your advice? Yes, go ahead, Magdalene Wangui. Try again.
You know, this question, they are not telling us how it has been encumbered. Is it caution or inhibition, or I'm overthinking?
No, it's okay. It's encumbered. Could be any of those. But what is the import of having such? How would it affect? Basically, they want you to tell her how would an encumbrance and the fact that the owner is deceased, how would that affect the transaction? How would that affect her interest? Probably if she needs this to move quickly, the owner is a deceased, we'd have to go through succession and everything else. This will take time, and the property can only move after succession is done. If she intends to move very quickly, then probably this is not the right property for her, unless she's willing to wait for that process to be done. The property is encumbered. Unless she's willing to buy the property with encumbrance, then this is not the right property for her. Why? If she's to buy it like that, she has to first wait for the succession process to be done. Then secondly, wait for the encumbrance to be removed. If she doesn't want to buy it with the encumbrance, that is when she'll buy it. Basically, this transaction might take a very, very long time because nobody knows when this process will be completed. Is this okay? This transaction will delay. If she's in a hurry, this is not the right property for her. She'd rather go for another property. Does that make sense? Guys? All right, we'll move forward to the next thing. The next question is, okay, the next question is, taking into account the findings of the official search and your advice, IGLA insists on proceeding with the transaction. Explain the steps you would be required to take to ensure registration of a transfer in IGLA's favor is free of any encumbrance. So we're talking about encumbrance, not the fact that this person is deceased. So what steps would you take to ensure that this property is free of any encumbrance? Anyone? What steps would you have to go through? What would be required? Anyone? How do we ensure that properties are not encumbered? What do we do? What do we have to do? Yes, George?
I think in this scenario, she makes application to the registrar of lands. Then
George,
the registrar of lands.
She's not the owner yet, unless I can't just make an application if I'm not the owner for an encumbrance to be removed on a property that I don't own. So maybe just before you proceed.
Okay, thank you. I'm well guided.
You get, yeah. She's not the owner, but she doesn't want to buy the property with the encumbrance. What should she do? And what is the procedure? Guys, a discharge must be done if it's a charge. If it's a caveat, then the caveat must be removed. At least the issue must be sorted out. This must be done before transfer is done. So first of all, they'd have to confirm the type of encumbrance that we're talking about. Because again, as someone said it clearly, we are not told which one. Okay. Yes, where is Jacob? Oh, you're in. You've been quiet.
Good evening. Now, looking into the question, I was thinking that maybe I would question myself as to at what process is the if maybe there is an ongoing process to get the grant. But leaving that aside, I would ask the personal representative here to make an application to the registrar to remove the caveat, if it's the caveat, or to make an application to the court to have it remove the inhibition, or also the registrar if it's a restriction. That will be the first step. Or if it's the charge, then I would first of all, no, the charge has to be discharged. So that one that one you can't go to the bank. Now that one you have to start the process of conveyancing if you are buying a property which has been charged. I think that could have been what I could have gone with.
All right. That's okay. Thank you, Jacob. And I think sometimes, guys, what we just need from you is just that trial, just someone to try. It's quite important. It's quite encouraging. Now, you guys will realize that when you are getting into a transaction, first thing that you have control over is due diligence. The second thing is how that sale agreement is drafted.
Daniel.
It's everything. Yes?
Excuse me. On the point I was making, I think on the caveat or caution, the caveat or any person can make application on caveat. Not only the caveat, but any person who has the interest in the suit property can make an application.
Okay. All right. Okay, sawa. But okay, sawa. Let me also try to answer the question. So I want to believe that what you have control over here, you've done your official search. The official search is showing that there's an encumbrance. So, and this person still wants to move forward. How do you protect them? The sale agreement, guys. The conditions that we've been talking about in the question that we talked about the other time, you can protect this person through the sale agreement. Ensure that you have a condition stating that the deposit shall be returned if the caveat is not removed. Could be one of the conditions that you can have, that the purchase price shall only be paid in full if the caveat is removed, that you will only buy the land free of the encumbrance, free of any encumbrance. So through the sale agreement, you'll be able to ensure that through that agreement that you have, you'll be able to ensure that this person is actually protected. The transfer will not happen unless and until that caveat is removed. Have that as one of the conditions in the sale agreement. Another step that you will take is when you are receiving the completion documents, before you go and register the transfer, check through the encumbrance section, ensure that the caveat has been removed before you go to the lands registry to register the transfer. Ensure that the caveat has been removed before that money is sent through RTGS to this vendor. So first step is the sale agreement. Second step is when you receive the completion documents. Third step is just before you register the transfer. You could say anything. Those are ways through which you can protect this particular person. Does that make sense? Does anyone have a contrary opinion? Yes, Donna.
Mine is a question. So will we include the issue of now having to go through succession before all this can happen when answering this question?
I want to believe that the question is clearly and separately on buying the property free of encumbrance. It's strictly on encumbrance. I don't think it would be proper for you to first go with, removing it from the deceased to this particular person. Then now once you have a representative, they're talking about the encumbrance. I think it would be proper that we focus on the encumbrance and not transmission. Donna, what do you think? That's why it's 4 marks.
I was actually confused. That's why I asked. Sina maoni.
Okay. All right. I think it would be proper to focus on encumbrance. Yes, Jacob?
Daniel, maybe to be safe, would it cost anyone if they were to just take through a one paragraph of, we assume that the grant has gone through and the property will be transferred to this and then to this, and then now is when we come with the sale agreement to the beneficiary?
No.
I don't know. I was just thinking.
No problem. No problem. I think just ensure that you're not boring the marker, and the marker can see that, you are really leading. What you're leading towards is ensuring that the encumbrance is not there when that transfer is registered. No problem at all.
Thank you.
Yeah, you just have to ensure that, they're able to see that that's where you're leading to. Yes, Samuel Mwangi.
Okay, I'm thinking around, I'm not sure whether it will work, but I'm thinking around whether the vendor, the one selling, would have to maybe have a professional undertaking. Maybe, for instance, if it was charged with the bank, where they're telling the bank that give us the title documents so that give us the discharge of the charge so that the land is discharged. Then after that, we are able to sell the land to the purchaser, who is Egla in this sense. In this case, with the land having been discharged, then we'll give you the money thereafter.
Very, very, very possible. But in this question, you are on Egla's side. You are on the purchaser's side. Now, I don't know if you have much time, you could touch on that. but it would be proper to touch on that if you're on the other side. But now that you're on this other side, I think the only thing that you're worried about, I don't care how you'll remove the encumbrance, but I'm only paying you the full purchase price once it is removed. If it's not removed, I'm not giving you the money. And I'm ensuring that that is captured in the sale agreement. Okay, someone. But of course, yes, that is how it would go.
Okay,
What you're saying,
okay,
that is
you.
how it would go. Yeah, that is how it would go. Just that. That is not your worry right now. You just want to have the encumbrance. How they're going to remove it, that's the problem with the bank. But you don't want to see it. You don't want to see it after the transfer. All right. So they'll have to think for themselves how they're going to do it. Question 6. Bernard, go ahead. Bernard, please read for us question 6.
Oh, just reading. I thought you saw my hand. My hand is not up, but anyway, I can read.
No, Bernard. There's a Bernard BA. Sorry.
Should I read?
Yeah, you wanted to read. Go ahead. Meshach, you'll answer the question.
Okay, question 6, right?
Yes, question 6.
In 2011, the government of Kenya designated, in 2011, the government of Kenya designated 100 acres of land in Kajiado as public land available for allotment to private parties. The government surveyor, working together with the director of physical planning, prepared a scheme plan delineating the land into 81-acre parcels of land. Following due process, Andrew Simba applied and was allotted 1-acre parcel of land known as B23, following which he was issued with a conditional letter of allotment. On receipt of the conditional letter of allotment, Andrew Simba announced to his family that they were now owners of 1 parcel of land in Kajiado and that they would build a family home in the coming 2 years. He then locked up his precious letter of allotment in a safe. In May 2015, Andrew Simba visited the parcel of land and was surprised to find construction works going on. Furious and confused, he sought to know who the trespasser was. The project foreman informed him that as far as he was aware, the land belonged to John Mukora, who was in the process of building 4 houses for sale. Shocked at this news, Andrew Simba pronounced loudly that he would report the matter to his lawyer and that his lawyer would deal with whomever Mukora was. You are Andrew Simba's lawyer. Explain to him whether a letter of allotment constitutes a valid title. B. Advise Andrew Simba on the process of acquiring title from allotment. C. On your client's instructions, you have written to John Mukora, demanding that he stops the construction and vacates your client's land forthwith. On receipt of the demand letter, Mukora has appointed Blue advocates to represent him in the matter. Blue advocates have responded to your letter by stating that their client is the lawful owner of the parcel of land pursuant to a certificate of title dated 17th June 2014. Advise Mr. Andrew Simba on which of the 2 documents is letter of allotment versus Mukora's certificate of title takes precedence. 3 marks. Thank you. Daniel,
Yes,
I'm
Meshach,
done.
Thank you. Thank you so much. That was very clear. The first question, what's the answer, Meshach? Explain to him whether a letter of allotment constitutes a valid title. Does it? Does a letter of allotment constitute a valid title? Anyone? Bernard, do you want to answer?
I can answer. Yes, I would say it doesn't. A letter of allotment does not constitute a valid title.
Yeah, it's basically an offer to actually get the title. It's not It's not, and this guy got it and put it in his safe. So he had an offer which he didn't accept. And we all know what happens when you're given an offer and you don't accept. There's no contract whatsoever. Yes, Jacob?
Yes, they say that it has to be registered for it to confer title. In the Gitwanyi case,
yes, but also there's a process that you still have to go through. Apart from that, registered, acceptance, payment. You see, it's a conditional letter of allotment, meaning there's something that he was to do before they move forward. But yes, that's also proper. So what he had was an offer, which of course is supposed to be registered as stated by Were. He did neither of those. He did not meet the conditions or anything else. He thought he had reached the end, yet he was just starting. So he had no title. Of course, there's no contract since what we have is an offer. Advise Andrew Simba on the process of acquiring title from a letter of allotment. Anyone who'd like to try that? Anyone? The process of acquiring titles from a letter of allotment? I have an answer, but it's from an article. It's not from law. I'd have to confirm that. And my answer is this. This is the procedure for allotment. I'll confirm the legal provision. So first you have an application. You submit an application to the National Land Commission for the desired land. The application should include details such as the purpose of the land, location, size, and any other relevant information. Then two, we have evaluation. The National Land Commission will evaluate the application based on various criteria, including the availability of the land, suitability for the intended purpose, and compliance with relevant laws and regulation. Three, offer. If the application is successful, the National Land Commission issues an offer letter to the applicant, which is the conditional letter of allotment. This letter outlines the terms and conditions of the allotment. The letter will also specify the fees payable for the allotment. Then number four, we have acceptance. The applicant must accept the offer and its conditions in writing and submit the acceptance to the National Land Commission. Then we have number five, payment. The applicant must pay the statutory fees required in the letter of allotment. The fees may include survey fees, land rent, and other charges as applicable. Number six, receipt. The applicant must obtain a receipt for the payment made and note the number given by the National Land Commission for future reference. Then lastly, number seven, issuance of title deed. Once all the fees have been paid, the National Land Commission will process the title deed and issue it to the allotee. The title deed is the legal document that confirms ownership of the land. I'll just repeat quickly. Application, where the applicant will submit an application to the National Land Commission. Evaluation, the National Land Commission will evaluate the application. Offer, if the application is successful, the National Land Commission will issue an offer in a letter of allotment. For acceptance, the applicant must accept the offer and its conditions. Payment, the applicant must pay the statutory fees required in the letter of allotment. Receipt, the applicant must ensure that they have a receipt for payment made. Then lastly, issuance of title deed. Once all the fees have been paid, the National Land Commission will process the title deed and issue it to the allotee. The title deed is a legal document that confirms ownership of the land. I'll confirm with my notes if I'm able to find the exact provision where I got that from. The second question is
Excuse.
Yeah.
Can you just start again from where you said after evaluation you talked of an offer in a letter of allotment? Can you just repeat again the process from point 3, from the offer in a letter of allotment?
Okay, offer. If the application is successful, the National Land Commission issues an offer letter, which is called the conditional letter of allotment. This letter outlines the terms and conditions of the allotment. It will also specify the fees payable for the allotment. Then number 4, excuse me, will have acceptance. The applicant must accept the offer and its conditions in writing and submit that acceptance letter to the National Land Commission. Then 5, we have payment. The applicant must pay the statutory fees required in the letter of allotment. Number 6, we have receipt. The applicant must obtain a receipt for the payment made to the National Land Commission. Then lastly, number 7, we have issuance of title deed. Once all the fees have been paid, the National Land Commission will process the title deed and issue it to the allotee. I want to believe that that is clear.
Okay, thank you.
Welcome, Meshok. Last part of the question, I see time is well spent. On your client's instructions, yes, the way Bernard read, advise Mr. Andrew Simba on which of the 2 documents, his letter of allotment versus Mukora certificate of title takes precedence. Anyone? Just unmute and speak. Which one takes precedence, guys?
I think
The second of time.
Because it confers ownership.
Okay, then we also know about the Land Registration Act. Is it section 36 or 38? Anyone who can confirm? That talks about prima facie evidence of ownership. 36 or 38, anyone?
Yes, I think that's the correct point. The state of title is a prima facie evidence unless it was illegally acquired. I'm not sure, but
Yeah. All right, guys, that paper is done. I hope you guys have seen how the questions have been answered and why you just have to be open-minded when answering these questions. I know sometimes we get so streamlined. Sometimes we feel like this is how it should be, or it should be hard, or it should be this way. But I'd just like to encourage us to, the way we've answered the questions today, let's just be open-minded, look at how the question can be answered, and we will be fine. Now, anyone with any question before we close? Please, the floor is open.
I have a question. That article that you read or you gave when answering, I think, part 2 of question 6. Please, I'm seeing that I'm kindly requesting that you share with us.
Sawa. Noted, George. Any other question? Do we have any other questions? We don't. Okay, guys. So I think it was a nice session. Thank you guys for participating. Thank you guys for showing some support to Caroline. Thank you guys so much for being able to answer the question. Now, again, I'd just like to encourage us, let's continue being active. Let's continue stretching ourselves, doing our best. And I want to believe that at the end of the day, CLE is going to be history. One thing that I believe is that we can all make it. We just need to put in some effort. Guys, it's not life and death. We can do this. We can do this. We are brilliant people, and we can do it. I just want us to know that it's possible. It's possible. It's something that can be done. So do not let anything convince you that this is impossible, or no one can do it, or people struggle, or the whatever. Everyone writes their own story and you are writing yours. And I want to believe your story is a story of success. Believe in it, keep pushing, keep going. And I want to believe that you'll be able to get the right results at the end of the day. Again, one thing that I told you guys is let's forget about our orals right now. Please don't boast about orals. Don't worry about orals. Let's work as if we don't even have oral marks. We're looking for the whole 50 here. So put in all the effort that you can. Just push as much as you can. Anyway, if you get more marks, what's the problem? It's good for you. So let's just push as much as we can. Forget about orals, forget about the project work. Let's push as much as we can here, and we'll be able to maximize our chances of getting that 50 and above. Again, I continue to wish you guys all the best. May you continue to receive grace and the ability to keep moving and going forward. And I also believe that you guys are going to do well. You participate. Your answers are really good. I want to believe that you guys are putting in the effort, and you'll be fine. It's gonna be okay. I'm present and available. If you're feeling anxious, if you want to talk to someone, anything. Again, mental health is very important. I'm not trying to say it's that bad. If, underline if, I'm available, just text before we have that conversation. Whether you are a woman or you are a lady, or you are a man or a boy, there's no problem. We can always have a conversation. We're in this profession, we have to do it together. Okay? So please do not be worried at all. Okay, so who's going to pray for us today? Barak, what if you pray for us today? Okay, Bernard, pray for us today.
Oh yeah, did you call me?
Thank you. Let me pray. I've never had Barak pray. That's why I was wondering.
I'm ready. I'm ready.
Okay, Barak, pray for us. Pray for us, senior.
All right, no problem. Okay, let's believe and pray. God the Father, Son, and Holy Spirit, we come before you. We want to thank you for everything that you enabled us to do tonight. Lord, we commit everything into your hands. You say that a man's heart plans, but you guide his steps, Lord. We commit all our plans into your hands. May you guide our steps, Father. May you fight for us always. You fought for Daniel. You fought for Gideon. And in all battles, Lord, you fought for those who believed in you, Father. And so I commit all of us into your hand. May you fight for us. Lord, I commit our facilitators. They have taken their time, their talents to help us. May you bless them. May you bless them abundantly. We commit everyone as we go to sleep, Lord. But in everything that we are going to do, Lord, may it be to the glory of your name. Lord, I pray this, believing and trusting in Jesus' mighty name. Amen.
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 God bless you, Barak.
Amen. God bless you, Barak. Okay, guys, thank you so much. See you again another time. See you again another time. All the best, guys. Keep going, keep pushing, man. It's all right.
Thank you, Daniel. Always thank you.
May God strengthen you and bless you, Daniel, and our tutors.
God bless you too.